Thank you. Good morning, everyone. I'd like to call the meeting to order and acknowledge that we are in Treaty 1 territory, the home and traditional lands of the Anishinaabe, Ojibwe, Innu, Cree, and Dakota peoples, and in the national homeland of the Red River Métis. Our drinking water comes from Shoal Lake 40 First Nation and Treaty 3 territory. My name is Neil Harden, and I'm chairing today's panel. With me are Carrie Linklater and Brent McIntyre. The assessor today is Jeremy Pohl, and the administrative personnel is Sally Caulfield. To the Zoom participants of the hearing, please note you are placed in the waiting room until your property is called upon. When it is your turn, you will be admitted into the meeting. Kindly follow along in the City of Winnipeg's Board Revision YouTube channel for the hearing process. Once the host admits you into the hearing, please close or mute your YouTube player. You will then be permitted to speak with respect to your property. Once your hearing has concluded, you can leave the meeting. We will be hearing applications for revision of the assessment rule in accordance with the Municipal Assessment Act. The matters for which revision is requested have been described in each application and will limit discussion to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matters must be sworn in. Be advised that comparisons of assessments of properties are not considered evidence of market value by the board. The board is appointed annually by council and is independent of it in the city administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order that be mailed to all parties as soon as possible. Please note that the board's decisions with respect to an application may be appealed to the Manitoba Municipal Board if the matter pertains to assessed value or classification, or to the Court of King's Bench if the matter pertains to the application of exemptions from taxation. Should you wish to appeal, information how to do so will be included with the board's order. With respect to the hearing process, I will confirm the points of appeal with your property to be addressed with each applicant following the swearing in. We will then have the assessor's testimony followed by questions the applicant may have, then the applicant's testimony followed by questions. Each side will have an opportunity to summarize if they wish. Once all the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each item on the docket today. The session will close after all the applications be heard, and the board will deliberate in private and make its decisions. You'll receive the board's decision by registered mail as soon as possible. As information, all public hearings are live streamed, recorded, and will be part of the public record. We will be hearing items 1 through 7 on our docket today. The first item on the agenda is 520 Portage Avenue. Ms. Caulfield, please affirm the assessor's and applicant's testimony.
Please state your full name.
Jeremy Reinhold.
Do you affirm that the evidence you're about to give at this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Please stand. State your full name.
Richard Ernest Olszewski.
Do you affirm that the evidence you're about to give at this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state your full name.
James Singer.
Do you affirm that the evidence you're about to give at this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right, so like I said, the first item is 520 Portage Avenue. So Mr. Pohl, you can begin.
File number is 25477. Roll number is 1209755200. The civic address is 520 Portage Avenue. The 2026 assessment is for 108,000. It's classified as 20 residential, 2 and taxable. It is a parking structure. If we look, second stall parking structure, we look on page 8. It shows where it's located. Located beneath the condominium, residential condominium, on the corner of St. Mary's and Portage. Access to it is through a lane off of St. Mary's. If you look at the bottom picture, you see that there is 3 doors to gain access to. In the next picture over on page 9. I haven't visited the property just before the panel, but we did have an inspector there in June 2024. These are pictures from that. There are three doors that you see. One is an entry door to gain access to the parkade. The other two are direct access to the parking stalls, the two parking stalls that you see in the first picture. So it is somewhat an atypical layout for a parkade. Typically you have a greater than 7 stall parkade. In this case here, it's on grade, it's at street level, and there are 3 entrance doors to the parkade itself. So as we can see through the building, there is signage for in-park. In-park is a parking operator. They usually operate a parkade, and they collect a fee from management as for the operated for management. Their fee is typically from driving up the rents as high as they can be through any parking, whether it be a parking or a parking lot, they're there to generate the maximum return for the owner, and then they collect a fee based on that. So as we can see, there are signage throughout the parkade. A couple stalls don't have that in-park signage. It's for condominium units. As you go through on page 10 shows the same thing, where it's reserved for in-park on the next page over, and then it's reserved, but there's no in-park signage there. So as you go through the parkade, that's it. Basically speaking, I do have in my rebuttal, I do have a better layout of the parkade, and I'll address that once we before. But there is a confirmed 7 stall now. So on page 15. It's indicated here on the 90 that was returned. It's not an office, clearly it's residential up above. It's indicating that the stalls are at $150 per month for a yearly income of $12,600. Again, we're talking a 7 stall parkade, and that the condo corp pays condo fees and maintenance for the parkade and charges back to the renters through the rental fees. So we get to the actual comparables. We look on page 3, page 4. It's a standard citywide comparables that we use. But having said that, when we look at what the model we put in, the model rate we put in on page 5, we put it in at $60 net a stall. That's the lowest I've seen. That's the lowest there is for a parkade. Typically it's greater than that, but in this location, we put it in at $90 a stall, so it's already at the lower end. We do have our standard cap at 7%. So net operating income wise, it produces $7,560. Capped at 7% gives us $108,000. Again, we're only dealing with 7 stalls. So that's why the NOI is what it is, the value. So it's a pretty straightforward basic workup. We do it on a fee simple approach, unencumbered by lease. So at $108,000, it's a modest value for arcade. But that I do think it should be confirmed. I do realize that today we do have a significant argument as far as how it should be valued from the applicant. But I do want to get into the fact that I did review coming into the hearing, the history of the subject property, and I just want to confirm that there was a June 2024 inspection done. It did confirm that there were 7 stall counts. It did confirm that there was signage that indicated that it was run by in-park. The overall condition of the parkade was in average typical shape, although the layout was atypical as I went through. The history of the parkade was that it was valued as $1 as a common element, but because it was reviewed, a condo element can't have an interest in itself, and we'll get to that as we go along. We did put a rule number to it, and we are valuing it separately. With that, I'm open to questions.
Okay, questions, Mr. Applicant?
Richard Olszewski for the record. Yeah, I have several questions. You said that in-park is managing the.
I see signage for in-park.
Right, so you're not aware if that's old signage or
All I see is signage for a park. I wouldn't expect it.
You have no evidence that there's any current contract with Impark?
No, just that, like I explained, there was signage for both Impark and it looked like other stalls that weren't signed by Impark.
Right, and if I told you that the previous owner, Hart Mellon, had used Impark and then was not using them after the condo corporation was given the parking the garage, would you have any evidence to?
No, part of this is discovery. I see the signage from the inspection that went through. Typically, when Impark has their signage, they are running arcade or parking lot, whatever the.
Other than that one sign, you have no evidence from the condo corporation that
No,
that's a cost that they've been bearing to hire Impark?
No.
Oh, all right, okay, so I just want to draw your attention to you've reviewed the applicant's brief.
yeah, but I'm answering questions on my brief.
But this goes to you had brought up that it was originally valued at $1.
Correct.
Okay, so this would help in clarifying.
I'm not going back and like I am acknowledging the history on that.
Okay. Are you aware that it and for the board's reference, and certainly they don't have to look at it right now, and then it'll be part of our submissions, but that in 2005 the previous assessment was $32,800, and then it was reduced to $1.
What page are you on? I don't have the tabs.
Yeah, so it just, you had said that it was originally valued at $1, but it was actually valued at 32,800
From the time of change. I didn't go back to.
in 2005.
Yeah, I didn't go back.
So you don't have anything to dispute that in 2005 it was
No, I don't.
valued at 30,800, then revised to $1.
No, I don't. I didn't go back that far in my analysis.
But you don't have any evidence to suggest otherwise.
No.
Okay, and so you don't have any evidence to suggest that up into 2023 the property was valued at $1.
It was $1 continuous, I believe, coming up to that point.
All right. And are you aware that that there's a declaration in the condo documents that is registered to the land titles office where at page 10 of that declaration it identifies the parking as common elements?
I believe it identifies unit number on page 3 as the condo, and the percentage of the common element is 0.41%.
You're not answering my question. Are you aware that on page 10 of the condo documents, or the declaration, it identifies common elements on page 10, and under common elements on page 12, it deals with parking?
Yes, I'm aware.
Are you aware that it's exclusive use common element?
Correct.
Okay, so what do you understand exclusive use to mean, common element to mean?
Exclusive uses of the condo corp.
No, exclusive use is actually of the unit holder that has been designated to use that spot.
From my understanding, there's some wordage that can be interpreted either way. I understand you have a Court of Queen's Bench ruling. What I'm looking at, it looks like the condominium corp, the corp has right to govern how they want.
Yeah,
So,
that's not correct. The condo corporation is, and I don't want to be argumentative, my apologies to the board, but the condo corporation has only the powers and jurisdiction that the declaration give it. And I'll get into the court case in my submissions, and certainly I'm not going to cross you on that.
I'm okay with you questioning a little bit here, because I mean, it's your argument that you're making kind of now, but I understand where you're going.
Well, no, I'm turning to the declaration. The declaration at page 10 has parking as a common element, and in particular, exclusive use common element, which means that whoever is designated a parking stall has exclusive use on it, okay? So, you can disagree with me, or you can have no comment and whatnot, but I'm gonna move over to your comparable. Sure. Okay, so let's turn to your brief, your comparables at page 3. Okay, so at 147 Provencher Boulevard, first of all, was that part of a condominium?
I didn't research as far as what the typically they are all.
So all off
Breakdown.
okay, and so would you know whether or not there was a declaration saying that it was exclusive use common element?
No, I wouldn't go into that depth of analysis for this area. Typically, just to answer your question, these are all recognizable as office properties. They're making a mixed use of some retail and a few of them, but this is generally a downtown arcade parking.
I'm gonna go through every one of these and ask you that question, so to save time for the board. Are you aware of any of these 15 comparables are exclusive use common element? And the parkers are entitled to park there so long as they own their apartment, their office space. Are you aware of
To
that?
be clear, that's not the scenario, that's not the situation for any of these comparables that I'm aware.
So you're saying that they are comparables, even though this particular 7-stall parkade has restrictions on who can use the parkade, meaning the owners.
We're simply looking at what the rents achieved in the marketplace are for underground parking.
And then I don't mean to be argumentative, but you're not answering my question. We can
I-
move
I
on.
said no, it's not the same situation.
Okay, so these are not comparables
I
with,
honestly are, but you're separating out, so.
if you just let me finish. So they're not comparables insofar as none of these, as far as you're aware, 15 comparables are actually owned as a common element. Is that right?
No.
Okay, so, all right, so let's get to your analysis with respect to your, on page 5, your market income. So it seems you're being somewhat generous to give it $90 a stall for indoor heated parking.
Right.
Why $90?
That's what the model predicted for this location. As far as what's usual downtown, when I handle the downtown portfolio, it's usually 110 to upwards of 120.
Isn't it true that indoor heated parking downtown can be $250, $350 per stall? I'm just wondering why the
100% that's true. Given the location, but we're taking it from a net perspective.
Okay, so what do you mean after deducting?
After deductions, we work
Oh,
on
sorry.
structures straight from a net perspective.
Right. Okay, so let's look at what the expenses are. So let's turn to your page.
But also, like, just to be clear, that $90 is a fee simple, unencumbered by lease. Rental. Right,
I don't know, how is that relevant?
meaning it's not based on a contractual site specific location, it's simple based on unencumbered by lease, meaning the marketplace itself, that's how you value. Property,
But we actually have the expenses here.
yeah, but that's contractual, that's site
No,
specific.
no. But we actually have the expenses here.
I am aware of that, but
So I just want to go through these expenses. You put them in your brief.
you know,
I think I'm entitled to ask you
Yeah.
questions about them. So the income you're saying is $90 net per month.
that's how we valued it.
I understand. Okay, so that's just so that I'm just for the board's sake, I'm trying to get back to where we you started from. So at page 18, you'll see that because, and I do have a title search that I'm gonna be offering to tender just to be helpful for the board when it's excuse my expression, our turn. But 8.41% interest in the common elements. Is that your understanding?
Yeah,
Oh.
page 3.
Right, and so on your page 18, 8.7% of the common elements is $210 dollars and 15 cents. Sorry, $1,210.15 per month.
If you're looking at the condo fees as you're seeing, as been reported to us on page 18 and 19, it's in my read because that's what was reported to us. Typically, when I'm looking for expenses related to operation of a parkade or parking structure, I'm looking for cost of heat, cost to electrify, cost of RMN, cost of things of such nature. I don't see that reported.
Right, and so are you aware that all the heat is included in the common element fees in that building?
But it's not giving me a breakout of one. It's just giving me a
No,
breakout
but
of the actual fees.
So it's a yes or no question. We can be here all day. I just want to be direct. So are you aware that in this condo corporation, and I can turn you to chapter and verse, it's going to take me a few minutes in the declaration, that the gas which heats the place is included in the common elements? Yes or no? Are you aware of
It
that?
is included in the comment, yes.
Okay, so you're aware of that. So there's no expense for gas because the entire condo corporation is paying for that gas.
I'm aware how the structure is, yes.
Well, then this should be very easy with yes or no, so we can just, I'm trying to establish a foundation here before it'd be very clear for the record if we could just move forward on that basis. So what you provided is every month $1,210 $1,210.15 as a common element fee.
Correct.
So this condominium corporation is very unique in that it owns a parking structure that actually has common element fees. And this all, and I'll go into this in our correct. And so if you add that up annually, those fees you will get $14,520 per year in common expenses. And the amount collected for condo fees, the amount collected for parking fees is 7 stalls at $150 per month, which is $10.50 per month, and per year is $12,600 per year, resulting in a $1,900.20 loss.
If you're looking at it from that perspective, yeah, it's a negative.
It's a negative. Okay. So would you say that any of those 15 comparables that you've selected lose money at that percentage?
Generally, I would say no. There has been instances where there is some R&M which inhibits use of the full parkade, but those are situations
In those particular,
but generally, no.
no, I'm talking about specifically with respect to your 15 comparables. Are any of those, please let me finish my question. Are any of those losing money?
Typically, no. I did not go through the financials for every single one of those comparables, but
So you're not aware of any of them that are losing money?
no.
All right. And so there's no mortgage, there's no interest, there's no on the income approach to value, and I appreciate that you use comparables and whatnot to try to whatever cap rate that you select. When a commercial property loses money, what is the value?
Typically, if you're losing money every year, you should be considering higher vacancy or higher parameters to account for that.
Okay, so let's work with the higher vacancy and is there any situation where this property under these economic circumstances with 7 parking stalls would be worth more than $1 on the income approach
I'm
to
looking
value?
at it from I think we're not coming in from the same approach. I'm looking at it from a board revision level as a as a value that is fee simple and encumbered by lease. What that means is on the reference statement. What would the market command for this location with market expenses? I would not be looking at it for the actual, like you're valuing it, or it appears to be how you're valuing. I'm taking a fee simple unencumbered by lease approach to this.
Sir, I'm using your documents to determine how you came up with the
$90 per
value.
stall.
$90 for stall.
That's on a net basis,
Right.
not a gross rent.
Right,
After all expenses for market
right.
rent, standard
So-
market parameters for expenses. To your net operating.
I understand.
And take a market.
Okay, so what would a typical buyer look like to buy a parking stall that all of the stalls are exclusive use common element and they're losing money? What kind of buyer would purchase this?
I can't really answer that. Like. Is any commercial investor, how we're approaching would look at it, what it could generate, what it can earn on a market basis. If you have.
Okay, so that was tried before, and I'll get into that, and that went to Justice Chartier, and Justice Chartier says, no, you can't do that. That's part of the common elements of the condo corporation, and then it went to the Court of Appeal.
Right.
And in that case, they said, no, you can't do that. What investor would go in there and charge higher rates when the Court of Appeal has already ruled that you can't do that? It's part of the common elements because of the declaration which specifies that it is. What investor, I'm asking you, you're saying an investor, what investor would buy?
I'm simply looking at the real estate as it sits. If there is a Court of Appeal document that says don't do it, that's your argument. I'll have questions for that. I'm simply looking at it from a market perspective.
All right, so I'd like to turn to your page 13. There's a door in the bottom picture.
Yep.
Do you know what that door is for?
Bear with me here for a moment. It's like it's access way to gain to the condominium. The stairwell to the.
No, so the door in the middle, I'm
So
sorry.
sorry, door in the middle. I just have the layout for the.
Could you share that? That's not in your brief. is it?
No, it's part of my file. Sorry, it's too small a print. I can't.
Well, if I
There's 2 doors there. There's one that goes to a stairwell. Obviously leading up to the condominium. But I can't answer that.
the middle door. What if I told you that that is access to the electrical and mechanical room? Would that surprise you?
No, it's typical in our case.
So. Sorry,
Arcades generally are in the basement, sub-level. There's lots of mechanical spaces that.
so would there have to be an investor that would be buying this in fee simple? Could they restrict access to this if they owned it? Let's say they didn't want to rent it out at all, they just wanted to leave it vacant or park their sports
You would
car
have to
there.
allow some kind of access to it, in this site specific situation. You need access to whatever is not mechanical. If you own that parking, you could block access you would need to have if you're gonna sell it. Whoever.
So would you be relying on a prescriptive easement? Because access was already been granted for,
I couldn't tell.
I think we'd have to wait 20 years.
I couldn't tell you exactly all the ins and outs of that. That's not my task for this appeal.
Okay. So you, before today, you weren't aware that that middle door was access to the,
No, I did not know what was beyond that. I knew there was access.
right,
Obviously.
and your position today is that an investor would have to let people through there.
If you're gonna be selling it and it's part of the above structure, and you need access to it, then clearly there needs to be some kind of that.
So there has to be some sort of agreement.
Yeah,
Is that what you're saying?
hypothetically, you're asking me hypothetical, but yeah, that makes common sense.
Well, no, you propose that they would have to have access. I'm just wondering how they would have access. If it's fee simple, please. If it's fee simple and it's owned and there's no, on the title, there's no right of way that's registered against that. There's no easement agreement. There's no access from any other part of the building. I'm just wondering, under what mechanism would you be?
I couldn't say.
All right. So at your page 15. This is the response. Correct me if I'm wrong, response from the property manager, Linden Property Management.
That's the response we received, yes.
Yes, and it says, so that says one owner. Winnipeg Condominium Corporation, this is in pencil or pen on the left-hand side, 479. Stalls inside are rented 150 per month or 7 tall stalls, yearly income of 12,600. You've reviewed this?
That's all there is to review behind.
Yeah, and so, and then at the bottom, what does it say? That
The corporation pays condo fees and maintenance for the parkade and charges back to renters through their rental fees.
right, and it would seem that that would not be similar to any of your comparables.
Typically, we have in park operating parkades almost exclusively or another parking operator, and it would be collecting and doing all the management for the owners of the parking. Okay.
So, you have no evidence that in park is just to be clear, because you keep on bringing up in park, and you have no evidence that in park is controlling.
The only thing I have is signage for in park on numerous spots throughout the parkade as is shown, and a few spots where they're on.
Sir, you're under oath. Do you have any evidence other than signs that could have been there for 20 years that in park?
Can we move on? I mean, we kind of
Yes,
covered
okay.
this topic before.
We have, my apologies, give me 1 second. Those are my questions, subject to any questions raised by the panel.
Okay, Ms. Linklater, any questions?
Thank you. Just a couple. So, Mr. Pohl, you indicated that this building was inspected in June of 24.
Yes,
Okay, and you yourself did not do the inspection, correct?
no, I did not. Field inspector from our office did.
Okay, and at that time of the inspection, the person who was there saw the signs indicating Impark was in control of this property or the parkade, correct?
Yeah, they
Are
took
they
pictures. They are the ones who took the pictures, and this is a visual evidence of physical parkade. We see signage. I can't tell you I can't tell you if Impark's still operating or not, just that their signage is still up.
All right. And you did not yourself investigate that, correct?
No, that was part of the hearing today.
Okay. And is your brief model driven?
Yes,
You
it
didn't
is.
you didn't make any changes?
No, and that's why I pointed out it is at the lower end of our rent that we put in. It's significantly lower than any other parkade.
All right. I thank you. That's all my questions.
Okay, Mr. McIntyre.
I have no questions, thank you.
Okay, I haven't any questions that haven't been asked and answered, so you can begin your presentation, Mr. Applicant.
Richard Olszewski for the record. So I have some history with this parkade. I purchased condo unit 305 in 2006, condo unit 307 in, I believe it was 2011 or 12. I purchased condo unit 306 and I believe it was 2018. In 2008 at a meeting with Colliers, Pratt McGarry as property manager and Hart Mellon as the developer. Hart Mellon pulled out a piece of paper showing that he had an option purchase agreement signed by himself as the developer and signed by himself as the owner of Unit 1. And I'd like to provide a current status of title. I think it would be helpful for the board. I've provided to my learned friend. I'm not sure that there's any objection to the status of title.
No, I have no objection.
You have no objection. All right.
It's shed some light on the confusion that this particular case would have for an assessor. And that's why I'm going into the history, the court history of this parkade. So if it's accepted, I think it'll just be clearer for the panel, Mr. Chair.
Okay. The panel would have to, this would be new evidence, fall under the heading of new evidence, and the panel will have to take a brief recess to consider
Well-
whether to accept new evidence or not.
Well, how about this? I will turn you to chapter and verse. In I believe the Manitoba Court of Appeal decision, which references the interest. It would be easier, I believe, for the panel to. So certainly, if it's up to you. If you'd like me to just show you chapter and verse quoting from the title from the Manitoba Court of Appeal, or I can just show you the title, which I think will be easier for the panel.
Okay. You're saying this is already included in part in your.
Well, no, the Manitoba Court of Appeal discussed both Justice Charche and the Manitoba Court of Appeal discussed the title and the ownership interest. And so by showing you a copy of the title, I think it just puts front and center the issue before us, not the ones that were kind of buried in this case. But I'm prepared to proceed either way if you want to take a recess.
Yeah, we'll take a brief recess to determine whether we will accept the new evidence. That's something the panel has to rule on as a whole. So we'll take just a brief recess.
Thank you.
All right, thank you. The board has convened and we are prepared to accept the new evidence. So Ms. Caulfield, can you share it in the SharePoint?
Alrighty, just give me a moment, please. If you refresh, it should be there now.
Okay.
Yeah, I have it.
Yeah. All right. Thank you very much. We've got it. So you may proceed with your presentation then.
Thank you. Mr. Chair, and distinguished members of the board. This appeal concerns a parking lot within a residential condominium at 520 Portage Avenue, in which 7 stalls, all occupied by residents, are considered exclusive use common elements. And in 2004, late 2004, there's a declaration that is at tab tab 4, which designates the parking as exclusive use common element. At paragraph 3. Now, in 2009, Robert Giesbrecht, who was the Condo Corporation's lawyer, and I'm going to get you to turn to tab 5. So just to give you some context and some background, and I have personal knowledge of this, that Hartmel and the developer was not permitting Unit 309's parking stall to be transferred upon the sale, and Ms. Marcicillin had asked the board whether or not we can get an opinion on the condo corporation's ability to transfer the parking stall to the new owner. And in accordance with the declaration, which was reviewed by Robert Giesbrecht, I'm looking at the second paragraph. And it says, the matter of designation of parking stalls is set out in 3.07 of the declaration. While drafting is not perfect, it would be tightened up somewhat. I am of the opinion that the proper interpretation of this section, that once a parking space has been designated for exclusive use of an owner, this designation stays with the unit. Accordingly, when the new unit owner of 309/311 520 Portage sells her unit, the buyer will be entitled as the new owner of the unit to the exclusive use of the parking space, subject to always the payment of a monthly fee. So that was in 2009, and Marcicillin had sold her condominium shortly thereafter, which was 309, and the new unit owner took that parking stall in accordance with this opinion. The same time, a lawsuit that started where Miss Marcicillin, as well as a couple other unit holders, including myself, had sued 520 Portage Avenue, 520 Portage Avenue Limited, which was the developer, not to be confused with Winnipeg Condominium Corporation 479, which happens to have the address of 520 Portage. For a declaration, amongst other things, that the parking garage was part of the common elements in accordance with the declaration and bylaws. And that was by way of statement of claim. The condo corporation on their own accord brought this matter by way of application, I believe in 2015. And I'm gonna take you to tab 9, no, tab 10. 2016 rather. You can turn to tab 9. Where Justice Charche held that in fact the condo corporation is entitled to be the owner and not Hart Mellon or through his corporation 520 Portage Avenue Limited to be the owner. And this was upheld by the Manitoba Court of Appeal. And so if you look at the status of title that I've provided to you, Winnipeg Condominium Corporation did not buy this. If you look at box 9, box 9, originating instrument is a transmission of land. It's not a transfer of land. This is a result of the court order giving it to the corporation. Unfortunately, we're in this unique situation where the condo corporation has as part of its common elements a title that has an interest at 8.41%, and we're looking at box 1 of the status of title, 8.41% of the common elements. Now, properly, the condo corporation should have a vote to change the declaration and bylaws to reflect the fact that the parking unit is a common element and not a title. But it amounts to the same. And I can understand how, notwithstanding almost 20 years goes by where the assessment is only $1, and then someone is looking at this title and says, oh, we have a parking garage, and by all accounts, it owns 8.1% of the interest. It doesn't seem like a common element at all. How could a common element have an interest in the common elements? Well, it's because the court ordered that it become a common element, and this just happened to be the title. So that's just that's the start of the confusion, and certainly the assessment department can be forgiven for not fully, and I say with the greatest respect, not fully comprehending this, because it is a little bit of mental gymnastics to understand that it is a common element, but it was taken from the developer that had it as a title. And this is not much different than a caretaker suite. And if you look at tab, in a moment. So tab 9 is the decision of the municipal board where the caretaker suite was analyzed, unit 203, and they came to the decision that it had a value of $1. And if you look at tab 4, no, it's not tab 4. No, it's tab 3. My apologies. Yeah, tab 3 is the corresponding city of assessment. City assessment. So I just want to make sure that we're I know I'm moving quickly here, that we're all on the same page. I'm at tab 4, the 2025 property assessment notice. Tab 3. At tab 3. Does everyone have that?
Yes.
Thank you. So you'll see on here some similarities. We have a title, just as we do with respect to the status of title that was just provided to you. And it's given a value of $1. Admittedly, the difference, which is plainly obvious, is that it has a 0% interest in the common element fees. But nonetheless, it's a separate title, which is owned by the common elements. And it wouldn't have to be. It could be specifically set out in the declaration and the bylaws as either having a title or it's just part of the common elements. Well, that's what the court ruled and was confirmed at the Court of Appeal, that this parking structure is connected to the common elements and owned by all of the unit holders. Assessments. Okay, so I'm at tab 7 and 4 pages in, and this is from the Condominium Act, section 43. It says assessed value for property taxation purposes. The assessed value of a unit is the value of the unit in its share of the common elements. Well, every single one of the residential unit holders gets a tax bill. And they have, every single unit holder has an interest in this parking garage. And so it goes that this parking garage has already been taxed by the city of Winnipeg when it does its taxation on the residential unit holders. It's no different than a hallway that is owned by the residential units. The difference that a hallway has as opposed to parking is clearly obvious, but I make that point to say that the residential owners are already paying for that hallway just like they're paying for the parking in their common element fees as well as in their taxation. With respect to my learned friend's submission that there's 15 comparables that give you a net value of $90 per stall, I would disagree that any of those comparables are actual comparables, in that they don't carry with them this restriction. No one can sell this. If the condominium corporation was convinced to sell this parkade to a third party or maybe one of the unit holders, the case has already been decided that they can't sell it because it is owned by all of the condominium unit owners already. They cannot dispose of it. No third party can own it. It's already owned. So I think I've made that point clear, and I'm sure you'll, if not, we'll move on. I'll take questions on that issue. I want to turn to the declaration, which is at tab. Yeah, tab 4. When you get there, I'm going to ask you to go to page 10, part 3, common elements.
Right.
All right, and the common elements starts off with use of common elements subject to the provisions of the act. This declaration of bylaws, common element rules, each owner shall have right to the use and enjoyment of the common elements in common with all other owners except as hereinafter stated. Such rights shall extend to each owner and members, immediate family and guests, or other authorized occupants and visitors of the owner. That's how it starts. So we turn now to immediately underneath it, exclusive use common elements. And then under exclusive use common elements at 307 at page 12. Allocation of parking stalls. This is subject to those owners having exclusive use of parking stalls, so exclusive use, used again, and pay a monthly fee. And enter an agreement for the lease of the parking stall. The owner of each unit shall have exclusive use at minimum to one or availability hereafter more parking spaces. So what this is saying, in essence, is that no one can own the parking because it's already owned as a part of the common elements. By definition, it can't be sold. This was recognized by Justice Charche in his decision in 2019, and then the decision in 2020 by the Manitoba Court of Appeal. The problem that we find ourselves in, I think it's worth repeating, is what we're left with is a title number that has an interest in the common elements, which is owned by all the residents and owners of the condo units. And just to be clear, I try to catch myself. Mano Simons College owns commercial condos on the main and second floor, right alongside of the parking garage. So when I say residential, I'm including the commercial as well. With respect to the market value, the income approach to value, as I specified in cross, there are 7 stalls at $150 per month, which is $12,600 per year. And I don't believe that this is the appropriate way to value. But because an income approach to value is how an investor would approach this, and as I already said, an investor can't buy this because it's been prohibited by the highest court in this province. If you look at the common element fees, which are listed in the assessor's brief, It works out to $14,520 a year, or $1,900.20 loss annually. And doesn't matter what capitalization rate, and I'm not challenging the capitalization rate that the assessor is bringing. It would be a negative. And so it would also justify $1. And then the previous treatment by this city, someone in 2005 convinced the city to change the valuation, and I'm looking at tab 2, sorry, tab 1, the first page of tab 1. And I'll wait for the panel to get to that. So tab 1, first page. The previous assessment was $32,800, and it was revised down to $1. Someone made the argument back in 2005 that this property should be treated with a notional value of $1. And then every year up until 2023, it was $1. And notwithstanding what the Manitoba Court of Appeal stated, someone that at the city in their wisdom had assigned it $170,000. And then last year we appealed. And I met with the assessor at the property. I explained to him that Impark was no longer managing it and hadn't been since the previous owner realized that he had lost it in front of Justice Chartier. And I also explained to him how my vehicle was being towed out of the parking the stall at the request of the owner by Impark. Notwithstanding it was chained up. And so he was aware of the heated legal battle, which ended up providing success for the condominium corporation, which ended up getting what was rightfully theirs. Without any notice, he reduced to myself or my office, who had filed the appeal. And I believe a notice was sent to the property management, and we didn't file in time. He had reduced it to $108,000. And so we are here again, or we're here for the first time, because we were assured that we would receive all notices to our office. And we're asking Mr. Chair and honorable panel that you revise it back to $1. This matter has already been decided in 2005, and it's not appropriate. Just as a skywalk is not appropriate, just as a caretaker suite is not appropriate to have any value, because it's not sellable. It has no market value. The only value it has is to the residents in the condominium corporation, who are already being taxed on all the common elements, including the parking lot. Those are my submissions, subject to any questions from the panel.
Okay, questions, Mr. Pohl?
Just a few, also the market aspect of it. You did not produce any comparables, you did not produce any expenses as far as market comparables, no capitalization rate. You're merely stating that it's worth $1 as a symbolic $1 is not worth anything.
No, I'm I'm. I did not think it appropriate. Given that. It is not correct to use the income approach to value. It's just that you did, and as a rebuttal. Even if we use the income approach to value. It would have a negative value. It's for completeness, it's not to suggest that. The value should be determined on. The income approach to value, it's so painfully obvious that if you look. At the income and expenses, it loses money, it's not the correct way to value this, the correct way. To value this is the market approach, and given that it's not sellable. Can't be sold. It has no value to anyone because no one can buy it.
But the individual condominium owners who have access to. Given there's only 7 stalls, would it not be more valuable if you're selling a condominium? If you have that exclusive right to that individual stall versus if you didn't?
I would agree that that would make sense, but you should be taking that up with the condominium owners' taxes.
So. It is accessible, it's just where does that assessment go and the tax burden would go with?
That's not the issue that's before us today. It's the condominium corporation.
Please turn to your page, I'm not sure what tab it's on, but in condominium declaration. Point 103, which is page 3 of condominium declaration. Sorry. So tab 4, I believe.
What page?
It's tab 4, page 3. I think.
Yes.
Identified here is the unit 1 is the parkade. Correct.
That's correct, yeah.
And percentage of common interest or a common element is 8.41%.
That's correct.
Has there been, since the court decision, has there been any amendment or any revision of the condo declaration?
Well, no, there has not. But I think that requires clarification. You need a vote to change, and I believe it's 80%. You need 80% of and 80% is through here.
So the condo corporation has the right to control or determine the use of the parkade.
It does not.
Does not.
No, it's specific.
If you had a vote.
No, even if you had a vote, it's exclusive use common element, meaning that. I suppose if we were postulating that all of the unit holders that had exclusive use parking decided they didn't want to drive cars and they proposed a change to the.
So they do have control.
So who has control?
They can govern their,
Who's they?
the condo corporation.
No, the condo corporation is just made up of the unit holders.
They have a vote.
They have a vote.
And if they decided they didn't want use of those parking stalls, they could transfer to another condo unit owner. Or a third party. Literally impart.
Conceivably, they could sell the entire building to a third party if all condo, you can uncondo a condo. So conceivably, that's all, but to answer your question, it has not been done. And yes, the unit 1, for the reasons that I specified with respect to the decisions at the Court of Queen's Bench that then was, and the Court of Manitoba Court of Appeal. It was only because the developer was trying to, for lack of a better word, steal the parking away from the unit holders and their rightful ownership to it under the declaration. This was recognized by the Manitoba Court of Appeal and Justice Chartian's decision, which they upheld, that it's always been owned by, as a part of the common elements, by the condo corporation, which means that it's owned by all the unit holders. And so you have this circular argument that if the unit owners all own a common element which has an, as you stated, an 8.71% interest, it can go on in for infinity, like looking in two mirrors in an elevator. It can continue on, but the court's already decided that to get past that. So I think that we can rely on the Manitoba Court of Appeals decision to say that it is a common element, notwithstanding what the title that has been provided to.
But you just clarify, you haven't amended or revised your condo declaration to reflect that decision.
Well, it would be absolutely the condo, but it's unnecessary given you have this Manitoba Court of Appeal decision that's clarified that it cannot be sold. It's owned by the unit holders and it's an exclusive use common element.
Just one other question here. I'm not sure if it's in your submission or not, but the income expense questionnaire that you provided to the department, you provided expenses as far as condo fees. Likely. And 9.
Yes.
Did you provide any of the hard costs, the actual cost of operating parquet, heat, electricity?
Okay, so as I mentioned before, heat is included in the declaration, is included in the common elements. And so there's no extra charge, so to speak, for heat. It's not, there's only 1 meter going into the building. This used to be the Supreme Court Racket Club, 1 meter.
Yeah.
They did not make several meters for that. So electricity is borne by the condo corporation. The same lights that light up the exterior of the building, it's my understanding, are lighting up the parkade.
So would you not then report all the costs for the actual building itself and then have a breakout? Or
how could you do that without separately metering it?
You just stated that all the costs are included with as one. Why would you just report that one cost?
But you would have to include the lights in all the hallways and in the washrooms. There's no water that's being used in that. But water is included. I don't know that. I don't know where that leads us to.
If you're looking at it from a market perspective of what the gross rents are versus the actual operating cost of the parquet, you could check from contractual basis from the site specific.
So
what the actual expense.
So if
can't do that analysis.
It's already worth less than $1 on the income approach to value. And so why would you include more spent
That
expenses that are?
your opinion. I was simply looking for the hard cost that one. That's all the questions I have. Thank you.
All right, questions, Mr. McIntyre?
Just one question, and this is for the appellant. Why didn't the condo corp remove the in-park signs?
I, as an officer of the court, not of this court, but an officer of the court, I can tell you that Impark has had no involvement for a decade in the property, maybe less than that. And I don't know the answer to that. And that picture is, for all I know, I don't live there anymore. I used to live there. For all I know, that sign has been taken down. I don't know if it has been taken down or if it's still there. I'm going to tell the board that we should agree to remove the parking signs because they're confusing to the city assessor.
Well, apparently they were there when the property was inspected in 2024, if I'm not mistaken.
Yes, but I have no answer to that. All I can say is that in Park, there's no evidence before the panel that in Park has any contract with the current owner, who is the condo corporation, and it follows by all the owners of the condo units.
Okay, that's fine. Thank you.
Okay, Ms. Linklater.
My questions have been asked and answered. Thank you.
Okay, and I have no questions. Mr. Pohl, you indicated at one point that you have a rebuttal.
Yes, I do.
Okay, is that in our SharePoint?
It is not yet.
Okay,
Do I have a?
I will email a copy to you shortly.
You don't have a.
I'm taking it to you. That's it. Oh,
Okay, it has been emailed to those. Panel, if you refresh, it should be there.
So how do I get?
Don't know, it's sent to your email.
would be mine, which one?
I have it, Mr. Chair.
yeah, I have it.
We have received.
What email do you have for us?
The one that you sent.
Jay Singer,
Yep.
nothing yet. Oh, no.
Richard O at OD LAW.ca and Jay Singer.
Oh, I just got it. Yeah, I just got it.
Sorry, I thought you printed out a copy for the, I can bring paper copies next time if
That-
that's allowed.
That's. I have it.
Most people these days don't come in.
All right, do you have it, Mr. Appellant?
I do, yes, I'm just reviewing it now.
Okay, Mr. Pohl, then proceed with your rebuttal.
Okay, so this is part of this is discovery, where there's some of it was regarding the in park. But first page is just generally a site layout of the subject property at 520 Portage. The next page over is just a blow up of the parkade. We see to the right hand side that that's the access lane. And I just want to give a full picture to the panel. The site, the site itself, the parkade itself that we're discussing. Our main points of argument are on page 3. I just wanted to confirm. And through discovery, there is no objection here. There was a inspection done in 2024 in June. There is 7 stall counts. That there is signage that indicates that the parking is being run by a park, or be signage of parking at one point is in there. The overall condition of the parkade is average and typical. The layout of the parkade was atypical, as we see from the pictures and from the layout. Our main point of contention is that the parkade unit is number one, has its own distinct title as a condominium unit with its own interest at 8.41%. We've already discussed that. And that there is no amendment we're looking at. And that the condominium corporation has the right to control and determine the parkade, use of the parkade. And the income that will be generated was confirmed at $150 per stall. Next question, or next page over is page 4 and 5. Through my investigation of the property, I just wanted to confirm this is adjacent to the parking lot next to it. This is a surface parking lot. It's run by Impark, it's literally right across the lane, and that there is a market here for parking. It's right next door. So I just wanted to prove out that there is a market here for parking. So with that's my rebuttal. I'm happy to answer any questions I have.
Okay, questions? Mr. Applicant?
Does the city recognize the jurisdiction of the Manitoba Court of Appeal over this matter?
Manitoba Court of Appeal, yes.
So, yes, and so notwithstanding that it's separately titled and has an 8.71% interest, that the Manitoba Court of Appeal says it's part of the common elements.
Not disputing the facts of the court. Written blank.
I'm sorry, my questions are long, my apologies, and so you probably anticipated my question. Let me regroup. So this is on Spanish case, that's fine. And so the conclusion that Justice Charche came to on page 22 at page 10, sorry, at tab 10.
Sorry, can I interject to the board? I'm supposed to be being questioned on my rebuttal.
Right, and so this is my apologies. Let me rephrase the question. Let me look at your rebuttal here. Okay, so you said at your paragraph 3 on your page 3, the Parkade Unit 1 has its own distinct title as a condominium unit with its own interest in condominium 8.41.
It's the same in a condo declaration. And there's been no revision since. Is any of that inaccurate? Maybe it's.
Sorry, I had seen some argument here. And my apologies that I don't have my reading glasses on, so getting a little gray haired for this online stuff. Oh, right, so it says the history, Parkade should not have been valued at $1 as it was in 2005, I guess you're referring to, is that correct?
Again, I didn't go back to 2005, I went back to the few years before it was changed. And this is what information we had on file. So that based on 0.3, yeah, it was incorrect.
So you're saying the city was incorrect when they revised it from 32,800 to $1?
I'm not saying that. I said I did review all the way back to 2005.
Okay.
I said the change. From
When did you
$1
review it
from
from?
$1 to the current is the recent change. So I didn't go back 20 plus years for this opinion.
You said the Parkade should not have been valued at $1 as if a common element because the condo cannot own interest in itself. What do you mean by that?
Exactly the circular logic that you were discussing earlier. You have a Court of Appeal document that stated one thing, we're waiting for a revision to the condominium declaration that's never occurred. You have a condominium unit.
Are you saying that
You have a condominium.
you're
unit.
saying that the condominium declaration has to be amended notwithstanding the decision of the Court of Appeal? Have you sought legal advice on this?
No, this is.
Okay, I'll move on. With respect to your monthly parking at the lot, it would immediately across the back lane on your page 4 and 5. You bring this up as a comparable, is that?
No, you're stating that there's no demand at this location.
Look,
There's no-
sorry, I did not say that there's no demand at this location. I said that you cannot sell no one can sell this common element. It's already been decided it can't be sold by the Manitoba Court of Appeal. So I'm trying to understand what the reason that you brought in this parking lot by Imperial Parking is to suggest that they have Imperial Parking is controlling the.
No, it's not being used as a comparable. I already have my market evidence in. I'm stating that part of this was, what my gathering from your argument was that there is no real market here. You can't generate any income here. Don't buy it. What I'm saying is, there's a parking lot right next to the building run by Impart. They're still running that parking lot.
I'm not suggesting that if this was, just to be clear, I'm not suggesting to the panel that if this was not a common element, that you couldn't attribute a value because there's no demand. That's not it. It's just that every one of those units or every one of those 7 parking stalls is assigned to a unit. It can't be sold, just like a skywalk or a caretaker suite, which is in materials. So if that's the reason that you're providing it, then I have no further questions.
Okay, questions, Mr. McIntyre, on the rebuttal?
I have no questions, thank you.
Okay, Ms. Linkletter?
I have no questions, thank you.
Okay, summation, Mr. Poole?
My rebuttal, page 3, you can basically see my summation. It's the same argument. It's laid out in 5 points. We believe it should be valued as such. We believe it should be valued on a reasonable basis under number by lease. We believe that we brought in
Okay, if I can go over this, your point 5 seems to be stating that the parkade is operated by Impark, but
Right,
your evidence does not show that.
I showed signing of it. Typically Impart would not keep their signage up if they were operating it through discovery.
I object. You're under oath, and my apologies to the board, but in all seriousness, you're trying to imply without any evidence, or there's a sign in there that Imperial Parking, you have to take that off the table.
I just stated that. I was getting to that. There's a signage there from an inspection through discovery. It appears that they're no longer operating it. So you can describe that up.
Okay, thank you. So continue with your summation.
Basically, we're treating it as a, like I said, unencumbered by lease, fee simple value. We're putting on parameters. Or as far as the rent, we're putting on the lower end of the range for downtown. And we think it should be valued as such. So that.
Okay, short summation, Mr. Applicant.
Yes, in my submission was as follows. Any confusion with respect to the ownership of this parking garage has been clarified by the highest court in this province. The condo owners have had to share this new burden of taxation over a parking lot that they're already paying taxes for as part of their common elements that are attributed to them in their tax bills on their residential units. You can imagine the cost in retrieving, although not relevant, but in terms of the passion that's demonstrated with respect on this, that the cost that the condo corporation has had to retrieve what was rightfully theirs, this common element of parking as described in the declaration on tab 4 at paragraph 3. And combined with the history on tab 1 that this matter has already been decided in in 2005 with a revision down to $1 all the way up until 2023. I'm not sure what percentage increase that is. But it's, I think 1,700%, or 170,000% increase, with no justification other than, my learned friend saying that a condo can't own a title that has common elements. There's no legal justification for that position at all. I would ask this panel, consider and read the two decisions that are before you at tabs 10 and 11, and reduce the assessment from what is now 108,000 back down to $1 where it's been since 2005 to 2023. Thank you. Those are my submissions.
Okay, thank you very much for your presentations. Panel will take a break until 11:15, and then we'll proceed with the next item on Galt Avenue. Thank you very much.
Thank you.
All right, thank you. Oh, we need to swear Mr. Storian.
Please state your full name.
My name is Jared Story.
Do you affirm that the evidence you're about to give at this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
All right, so the next property is Galt Avenue. So Mr. Pohl, you can proceed.
File number is 25-4036. Roll number is 130812811100. It's on Galt Avenue. The assessed values for 2026 is 476,000. If we look on page 6, parking lot. If you look a little bit below that, just shows where the location is, South Disraeli, and kind of bordered by waterfront and Lily, with the next major street being Overland Street, which is just a little outside of picture there. So below that shows a more close-up look at the lot. Standard outdoor lot. On page 7, just again a couple of pictures, and again on page 8, just giving a view what the lot is. So on the next page is the subject properties income and expense information. They submitted in 2022 for the year. There's parking income of 45,000. If you look over on page 3, it indicates that bear with me here. Sports Manitoba is occupying the lot. They're leasing it out for $37.50 a month. And then we have WH Escott as well. There is no rent there. It's a simple dollar. The next finding that I had as I investigated the property, I bring in a 2020 submission for that calendar year. Again, same $45,000, same general reporting. When you look on page 5, it becomes clear. Sports Manitoba is leasing it out. Sports Manitoba is obviously the building that they put up on the corner of Disraeli and Main Street there. Part of the lot being leased is them. The other part is owner occupied and there is no rent. So. And that's indicated, highlighted for you as well. So. When I looked as far as how we should value this, we do have a standard set of downtown comparables. I deviated from that a little bit to be a little bit more close to the subject property's location. So on the next few pages over are comparables. Page 8. We look at 308 Edwin. At the reference date, it's $95. month. And indicated signage. And that's adjacent to the subject property. We look at 189 Rupert at the reference date, it's $225 a month. See that on the next page over. It's about block and a half away. Main driver there again would be Sports Manitoba, as well as the museum, which is adjacent to it. Page 10 shows that there is hourly and daily as well, but monthly is reported at $225 a month. If you look at 55 Duncan, which is again adjacent to the subject property, it's at $145 a month. You look at 106 Alexander, which again is adjacent to Sports Manitoba, kind of right in the same cluster of properties. It's at $190 a month. And again, page 13 shows that its location is right by the Ukrainian Cultural Museum, as well as Sports Manitoba, and off to the south. So from that point, we do have local comparables right in that specific region, adjacent to the subject property, very close to it. And for our parameter that we have in place is on page 3. We have for 63 stalls, we have a $31.50 net, which produces a net operating income of $23,814, capped at 5%, is for $476,000. Given the comparables of what the subject property is leasing at, I think that's their assessment. That and open questions.
Okay, questions, Mr. Story?
Just very quickly, for my edification, Mr. Pohl, where is that stall count? How did you determine the 63 stalls?
That's what we have on record.
Okay, but it does, just to be fair, the owner is reporting a number much lower than that, correct?
Yeah.
Okay.
Yeah.
Okay, well, yeah, so I'll just leave my questions there, Mr. Chair. That's fine for this one. We'll have to sort through this in greater detail.
Okay, Ms. Linklater, questions?
I have no questions at this time. Thank you.
Mr. McIntyre?
My only question was the issue of the stalls, so I have no other questions.
Yep, and I had noted the issue with the stalls as well. So, Mr. Story, your presentation then?
Yes, thank you, sir. Just for the purpose of our exercise today, I'm going to request that the board confirm this assessment so that we may work through this issue of the stall count. I note that the owner is reporting 26, but I have inspected the property since, and there are indeed more than 26 stalls. So I would respectfully request that the board confirm the assessment for our purposes today. Thank you.
Okay, thank you. Any questions, Mr. Pohl?
No.
All right. Any questions arising from the panel?
No questions. Thank you.
Questions.
Okay, thank you. Then we shall move onwards and upwards. Well, onwards. I don't know if it's upwards or not. To 133 Pioneer. I better flip a page here. So 133 Pioneer. Mr. Pohl.
File number is 25-437. Roll number is 120938061100. 133 Pioneer. The 2026 value is assessed at $1,682,000. They have 47 outdoor stalls. We'll look at page 6. Again, highlighting where the subject property is. It's on the corner of Sherbrooke and I can't read them right. Pioneer. You really need to bring my glasses.
We should send a note to Visa that we require reading glasses to be stocked in each meeting room.
Funny note, I'm just wading into that. I've had them made twice and twice they still don't, I can't read from them. Like, I don't know. I'm trying here, but anyway. We look at page 8, the I particular point. We're looking at 133 and I highlighted it for you because we'll have some issues with non-compliance for the next appeal. But generally, this is what the reporting, 38 stalls. At $163 a stalls. If PGI was full month to month, there is is there any transient parking here? Is there any after weekend income? Not sure if that's being reported in the parking, reported at 74,214. But if you're just simply looking at what they're reporting the rent and that, it works out to be approximately the rent that's on the site. So look at the rest of the submission, just confirming the roll numbers that was sent. Yeah, package that we sent to this property, highlighted in yellow. The next page over is page 17, our comparables. Again, I'm going more site specific or closer to the subject property. 41 Westbrook. We have at $85 seasonal monthly, 215 reserved. Stall. On page 18, we have 0 highlighted in red, just south of the property across the street. We have at $220 random. And then page 19, 110 Pioneer. Again, just across to the east and just underneath the underpass of the rail line, we're getting $235 random. And if you look on page 20, 179 Pioneer, you're getting rents at $225 random monthly, reserved at $260 and or for 6 to 6, and $280 for reserved for 24 hours monthly. So with that, we turn back to page 47. You have 47 stall count, monthly rent at $92. Which gives a net operating income of $51,888 capped at 4.5%, gives the value of $1,153,000 rounded. All right, with that, I'm open to questions.
All right, questions, Mr. Story?
Yes, just a few. So, Mr. Pohl, just to be clear, this assessment came out at 1,682,000. Is it a recommendation then, based on the calculation on page 3, that it be adjusted to 1,153,000?
No, I apologize, I didn't catch that. Bear with me. So, workup, what was released on the roll was 1,682,000. The workup is for 1,153,000. What I can tell, there is 47 installs. The INE indicated that there was 38. And part of that was the property line kind of going between. Got here. No, I would suggest that it be confirmed in that meeting. You would be able to have just, or you know what? Can we have it adjourned? Can fact check? Because if this stall count is wrong, I want to correct that for the property.
We're very reluctant to adjourn hearings, we can give you a brief recess to check the stall counts or whatever you have to do, but we cannot adjourn it.
Sure. Can we get a brief recess?
Sure.
Thank you.
Until what time? 10 after 11?
Sure.
Okay. Thank you. Welcome back. Mr. Poole, have you been able to clarify your valuation?
Yes, we're going to make a recommendation to 1,055,000. And that's based on an adjusted stall count of 43 stalls after review. Potential rent is 47,472, capped at 4.5%, gives us 1,055,000 rounded.
So you said 43 stalls?
Sorry, didn't I? One.
Okay.
Yeah.
Yeah.
1,055,000.
And 43 stalls?
And 43 stalls, yes.
Okay. And Mr. Story, how do you feel about that recommendation?
Well, we're certainly closer, Mr. Chair, but I'd like to proceed as I don't have client approval, so I'll proceed on matters of cap rate only, and I promise to be expedient.
Okay. Do you have anything else on your you wish to state in your
Oh,
presentation,
yes,
Mr. Poole?
No,
No.
that's it's a straightforward.
Okay.
And I suppose I have some questions,
Yeah.
Mr. Chair. So
Questions, yes.
yeah, may I proceed with my questions? Perfect. Okay, and again, just very quickly, now we're simply discussing the capitalization rate effectively. So Mr. Poole, is that capitalization rate a prescribed rate that's applied to downtown parking, or how is that cap rate generated?
The model driven rate and our range
Model
is
driven rate.
4.5 to 5.5.
Okay, and just to be fair, in this submission, there is no cap rate evidence provided by the city. Is that correct?
No, it's a model rate. You don't bring in direct evidence for parking capitalization rates.
Okay, and just to be clear, because those cap rates are quite low, is it the city's perspective that surface parking is effectively, call it a holding pattern, it's transitional use, and so it's those low cap rates are based on the fact that it may be developed into something more productive at a later date? Is that the rationale?
I can't tell you that. I'm not a modeler. That's what the model produces. But generally speaking, any property has the potential to be developed, whether you're looking at it on itself or potential merger with neighboring properties. It's vacant land. But as far as the methodology, as far as how they get to 4.5 to 5.5, I can't tell you. It's treating it as a whole.
Okay, thank you. Now, one last question. This property, can we agree, based on its proximity to the High Line, is somewhat unique, and I guess the second part of that would be, do you suppose that the mandatory setbacks would preclude full development of the site? Is that a fair comment?
Yeah, you'd have to have that looked at, obviously.
Yep.
Or just simply diving in that operating to give up the parking concern.
Yes. Okay. Thank you, Mr. Poole. Those are my questions. Thank you, Mr. Chair.
Okay, Ms. Linklater, questions?
Yes, just one question. Mr. Poole, what was your revised NOI? I didn't catch that.
47, 472.
472?
Yeah, 472.
All right, thank you. That's all my questions.
Mr. McIntyre.
I just have one question on page 8. The mailer returned by the owner has 38 stalls.
Correct.
And you're using 43.
43, yeah. If you look at page 6, see the property line going kind of halfway through.
Oh, I see. Yeah.
I'm fine with recommending 43. That's what's advertised. We had it at 47, but there was a argument's sake.
Okay, thank you. That was my only question.
All right, so Mr. Story with your presentation then.
Yes, sir. Thank you very much. Once again, we're at 133 Pioneer Avenue. This is a best described as a unimproved surface parking lot. We had on record 47 stalls like the assessor, but in reviewing this file, as Mr. Pohl has rightly pointed out, it is indeed advertised as 43 spots, and that's on um, page 7 of my brief. You can see the listing from Indigo, where they list 43 spots. So this is now effectively simply a cap rate discussion. So I had asked the assessor if those very low cap rates for surface parking are based on what we'll call transitional use. I understand that that logic. However, the this property is unique in its proximity to the High Line. So we have increased the what I'll call the numeric assessment of risk by applying a slightly higher cap rate of 5.5%. So my net income is slightly higher than the assessors, but my cap rate is also slightly higher at 5.5%. So our request to the board today is to adjust this assessment to $938,000, and again, that's predicated on a net income of $51,600 and a cap rate of 5.5. I've submitted to you a downtown parking study. I know you've all seen this before, but effectively, we've looked through sales. Now it's a bit tricky, admittedly, because there's not a great deal of sales transaction volume, but we do consider the inherent risk of this property on a site-specific basis, and we also consider the fact that when we apply the cap rate, we have to consider the availability of other investment vehicles. So we know that at the reference date, a GIC was returning 5%. So it would stand to reason that a slightly more illiquid investment that requires management, that requires all sorts of other basically that has more risk and has more expenses should be applied a slightly higher capitalization rate. So that is our justification for the 5.5 cap rate. We do point out once again that the city has not provided any support from usually we see something from the brokers at a minimum, but there's no cap rate evidence from the city. So we do respectfully submit that the cap rate of 5.5 be applied on a site-specific basis. And once again, sir, this does lead us to an indicated market value of $938,000. Certainly closer now with the assessor's recommendation. But I will leave it there, and I thank you, and I'm open to your questions.
Okay, questions, Mr. Pohl?
Can you turn to the expense income questionnaire?
Yep.
You're reporting a parking revenue of 74,214.
Right. So yeah. So this is a property that served the Nutty Club across the street. So we've not disputed the methodology of looking to market. I've applied $200 per stall. I think you're slightly lower. So, but their reporting is based on how this property had been used when it was servicing the Nutty Club. This was their parking.
So that then follow again, the next point to the next question, when we see what they're reporting, was that like explain this was not open to market, was simply leased by Scott. I can't read the name. Bathgate.
I understand. Yes. So Scott Bathgate, that is the company. J.K. May, the ownership, and Scott Bathgate are both related to the operation of the what we'll call the Nutty Club. So those are related parties. So this is their parking.
So it was owner occupied effectively.
Yes, indeed.
Right. That's all the questions I have. Thank you.
All right, Mr. McIntyre, questions?
I have no questions, thank you.
Ms. Linklater?
Just one question, Mr. Story, and forgive me if I'm misquoting you, but did you say there's a risk because of the location of this parking lot to the High Line?
So yes, I'll expand on that. Typically, when we see the lower cap rates applied to surface parking lots in the downtown, it's based on the fact that parking is typically considered to be in a holding pattern until a more productive economic use becomes available. So you can develop that land, presumably. Now, the issue that we have here with the High Line is that the mandatory setbacks at grade, I don't have it in front of me, but I believe them to be about 30 meters. And they would be even more severe with an active High Line. You can imagine you have diluted bitumen and other products traveling by rail. So you have a limited development capacity on these sites that are adjacent to rail, further frustrated by the adjacency to the High Line. So in terms of the risk of ownership of a surface parking lot, we don't believe that a sub-5 cap rate is appropriate based on my comments of the return rate on the GIC. And we have looked at this from a site-specific view, and we do believe that the development capacity would likely be hindered by that proximity to the rail line. So that's why I made the comment regarding risk going forward for development purposes.
Thank you. That's all my questions.
Thank you.
Okay, in terms of risk, I mean, I don't think anybody's going to develop this. As number one, it's not a very big lot, and
Right.
number two, it's high, isn't its highest and best use parking for the ballpark, basically.
Or the Nutty Club, right? So I mean the Gold Ice Stadium, I believe, I could be wrong, but I believe they have about 50 home games a year. So that would not be completely maximally productive, but certainly it would be an accessory to the Shaw Park or the Gold Ice Park. But I would agree that the highest and best use would likely remain parking, and that again speaks to the adjusted cap rate where other similar properties may have development potential. We believe that this is quite likely achieving its highest and best use in its current state. So I would agree with that.
All right, thank you very much. So we'll move on to 131 Portage. Let me open those files. And we have a non-co-op requested on this one, so we'll deal with that initially. 131 Portage Avenue East. So, Mr. Poole, if you can read in the basic information and then proceed into the non-co-op.
File number is 25440. Roll number is roll number is 13060638000. Subject action is 131 Portage Avenue. The 2026 value is 1,560,000. We have a non-co-op request. You look on page. Sorry, page 8. This is the subject property and expense information that we got from the property owner. You will note that the property owner reported the incorrect property for the 2023 year. It's the wrong roll number. It's the wrong property. It's actually is the property that we just dealt with prior. We look through, they're writing in from a blank sheet, they're filling it in. We looked for the proper information for this parcel. It seems clearly not. The next page over is on page 12. We see what we sent to them, to their service address of the 149 right here. Went to the right place. Obviously, I mean, it's not a question if it didn't go to the right place. We got a response, so that's not the point to failure. Page 13, highlighted in yellow. It went to. We are asking for 131 Portage with appropriate roll number. So we did send them the right INE, and that's just highlighting for you. And then I also brought in, and that's the point of failure for that year. So they filled out the wrong one. And then I look back as I always would. For the next subsequent years, Then they did fill out the proper one for 131 Portage. For the 2021 submission, so we can go through that as well. But at that point, they did provide the wrong information for the wrong property. That point, it for us seeking a non-compliance. Section 53(3)B has written. So,
Okay, is that your submission on the non-co-op?
yes, it's pretty straightforward. Yes.
Okay, questions on that, Mr. Story?
Yes, just very quickly. So Mr. Pohl, you've quite rightly pointed out that this is this form is the same form that we saw for 133 Pioneer, and it is not indeed filled out on the prescribed form, but rather one of the blanks that a ratepayer can download from your website, correct?
Correct.
Okay, so then is it conceivable that there was an administrative error made on the city's part by filing this INE with this property? Is that conceivable?
I didn't find that. I've actually looked at the other properties. I couldn't find so we have a few. It wasn't submitted, it wasn't filed in a different property that they have ownership over, so I didn't see that.
Okay. Okay, I think I'll leave my questions there, Mr. Chair. Thank you.
All right, Ms. Linkwater, any questions?
So I believe you stated, Mr. Pohl, that this property doesn't have a history of not reporting, correct?
They reported it this particular year, they give us the wrong property questionnaire.
So when that error was discovered, did anybody just give them a call?
No, I believe I was the first person to discover that. Hence, I'm not asking for the giving of recognition. I still think the property with the right information.
All right, thank you. That's all my questions.
Mr. McIntyre?
I have no questions, thank you.
Okay, just for clarification, then, did you state, Mr. Pohl, that you did look to see if somehow it had been misfiled or?
There's a couple other properties, like we just put out the other deal, like I just checked to see what was submitted in the other. For the other roll numbers, and it wasn't there. So as far as I tell, they simply submitted the same INE twice, or one for the right property and submitted the same one again, the incorrect property.
Okay, so you feel, would it be correct to say that you feel that if an administrative error was made, it was made on the owner's part, not the
I would be seeing that INE filed under one of the other roll numbers. It's not.
yeah. Okay. Thank you very much. So, Mr. Story, on the non-co-op.
Yes, sir. Thank you. So I do see that there indeed was some error made by one of the parties, and I have at this stage I have instructions from my client to request confirmation so that we may dig into this a little deeper, and that will preserve their right to appeal. So I will respectfully request that the file be confirmed for our purposes today, allowing us more time to see exactly what was filed and if there was an error, where that occurred in the chain. So that's my presentation for you today, sir. Thank you.
Okay. Questions on that, Mr. Pohl?
No, I don't have anything.
Okay, Mr. McIntyre,
I have no questions, thank you.
Ms. Linklater.
I have no questions, thank you.
All right, so I have no questions. So thank you very much then. We'll proceed on to the next property. Ms. Caulfield, is Mr. Neufeld available?
He is not currently online. May we take a recess and I will contact him? Sure,
and take a recess and we will come back. Well, let's try at 11:40 and at that point. Thank you.
Thank you, everyone.
Thank you, Jared. Okay, thank you very much. We will move on to 1400 Keniston Boulevard. So Mr. Paul, you can proceed.
File number is 25-26-5. Roll number is 04007137400400. 155 Elijah Modi Boulevard. The 2026 assessment is for $5,921,000.
We're on Keniston, 1400
Oh, sorry,
Keniston.
did I get off? Oh, wait, my mistake, read the wrong.
Mr. Chair, if I may just interject
Sure.
to affirm the applicant,
Oh, that's right, too. Yes.
thank you.
Okay.
I get the
We've been here too long.
Yeah.
Please
Yeah.
state your full name.
Rocky Neufeld?
Do you affirm that the evidence you're about to give at this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Let's try this again.
Okay, I'll interject here. On 1400 Keniston, we have quantum, class, and liability. So if you can read in the basic information, Mr. Pohl, and we'll deal with class and liability.
Sure. File number is 25237. Roll number is 10006776070. Address is 1400 Keniston, and the 2026 assessed value is 10,822,000, and that's class code 60T.
Okay, Mr. Neufeld, then on class and liability.
Yeah, I don't understand it. I think, well, we've got a new admin person and I think she's just checking all the boxes off. So there is no class and liability issue.
So you're requesting confirmation of class and
Yes,
liability?
yeah, yes, that'd be a good idea, yes.
Okay, then Mr. Pohl on quantum then.
Property is built in 2015. We go through on page. Starting on page 11 is the photos of the property. Property is a car dealership. Adjacent to Keniston. And it's off of Rockwell. So if you look on page 12, there's more blow up of the individual property. It has good exposure along Keniston. On page 13 shows the building itself. It's a Mercedes-Benz dealership occupying the property. As we go through it, and I'll just generally just turn the pages as we go through. It's a high-end dealership, obviously. Go through all the pages, gives you the showroom to start with. It then converts over to page 21, the mezzanine area, which looks over the showroom. The individual offices that are up on the mezzanine area. On page 24 shows there's elevator service. Both the mezz, main, and there's a lower level as well. And next page on 25 is the stairwell. And 26 shows that the stairwell, again, goes down to the lower level. 26 shows a bit of the lower level, and 27 shows the ramp leading downwards. 28 and 29 shows and so forth all the way through the end of the pictures show that this level is being used to store cars, detail, whatever climatization of the vehicles if the outside limiter or whatever the case may be, bring them in. Page 33 is again elevator services again down through all three levels for the mezzanine, for the main floor, and for the world up. So on page 34 is the INE. It's checked off as owner occupied. They fill out all the costs. There's no issues there. And just like every other car dealership, they are all owner occupied. This is an educated panel today, so I'm going to try to save time. We are fully aware, everyone should be aware that there is a car dealership test case that happened in June. I was part of that. We're waiting orders from that. I was hoping to have it hoping for them to be released by now. It still hasn't been. So we're still going on the emphasis of that we are using our big box retail argument. I've included the same package that we included for this cycle. So it's order number A02223 and highlighted for your convenience on page 49 is that the board is satisfied, and I'm just paraphrasing here, go through it. The board's finding for this appeal for Waverly property for car dealership is the board's satisfied that the appropriate method for the subject property is the income approach. There was some argument that it should be done on the cost in the past. It's the income approach, it's the same approach I applied at the municipal board. I did not do direct sell and I did not do cost. It was the income approach solely. And then highlighted in the lower red box speaks to where they're getting their capitalization rate and shortfall rate from. And that's, I'll just read from it. The board accepts the argument that auto malls and agglomeration of auto dealerships located in different sectors of the city result in an auto mall having characters similar to regional retail with national rather than local tenants. The board is satisfied that subject property is similar, although not identical, to large national and international retail properties located in or near regional shopping facilities. So the take on that is that's where they're saying the risk should come from. That's what we presented to the municipal board. As far as how we value this property here, I've done the same basic workup on page the rent, you go on page, starting on page 3. There's 6 areas of the city that have car dealerships. Regent, Boulevard, Pembina Grand, McGilvery, Keniston area, as well as your Garden City area and your end of Portage area, West Portage. So those are the 3 that are 6 that we've reviewed. We're using big box retail as our argument to take economic substitution for the lowest rents for this out here today. So we look at Keniston, starts on page 5. This would be the closest location to the subject property. We see that the weighted average for 416,000 square feet of inventory, average median CRU size of almost 18,500 square feet gives an average rent of $21.51, weighted average of $20.91, and a median of $20.31. So you see it's around $21 a square foot for this kind of retail. If you take back to our income approach on page 8. Again, we have C2, which is 36,219 square feet at $14.15. That's your main and upper. And your basement leasable, which is the lower level, at $11.33. Gives our total potential income at $701,113. You see that those rates are significantly below what the market is in that area. These are model generated rents. These are model generated parameters. I'm comfortable recommending them here today. We will be reviewing municipal board order, the guidance that we'll get from that, and we'll be looking to review that and possibly implement what we can out of it. But for this appeal today, I'm comfortable recommending the model value. So I'll go through it now. Leasable area is a total of 52,837 square feet. Again, getting back to $701,113 for a PGI. Vacancy at 2% gives effective gross income of $687,091. Expenses at 3%, shortfall at $6 gives a net operating income of $660,138, capped at 6.1%. Gives a capitalized value of $10,822,000. So with that, for our model parameters for car dealerships, I'm comfortable recommending the $10,822,000 support today. That will open the questions.
Okay, questions, Mr. Neufeld.
You The, sorry, the rents starting on page 3 and 4, 5, 6. Are automobile uses permitted on these shopping centers that you took the rents from?
As the zoning, I did not do an analysis for that for this particular appeal here today. These are simply taking the retail rents, putting them to the subject property
So the answer is you did not check.
for
Is
this
that correct?
for this appeal now.
Okay. So how did you determine whether or not these were legal uses then? That would be comparable to an automobile dealer.
We're taking the principle of economic substitution. I think I made that clear. We are at the municipal board waiting. I'm sure it's going to be released very soon. They'll determine whether this is a correct methodology or not. So at this point in time, for all car dealerships, I'm simply asking for it to be confirmed.
Well, I don't care about that answer. I just asked you a question. How do you know they're legal?
There are retail leases that are in place.
But not for car dealers, correct? Not for automobile related work?
Again, none of the comparables are auto car dealerships or related.
But my question was, would they be legal uses in the areas that you have mentioned here? And I know we've been through this matter before, that most all of these are in shopping centers that do not permit car dealers. Isn't that correct?
I would, that would be a safe assumption, yes.
Okay. Now are there any basement rents in here?
No,
Okay, so how did you come up with a basement rent of 1135?
it is a model rent and it is far below what the market is for.
I didn't ask your opinion. How did you find it? Just
It is a model rent.
okay. So, and just to confirm for the board, the basement would be accurately depicted on page 28, is that correct?
Yeah, I thought I clarified that.
29, 30, okay. So
Sorry,
this,
on page 26, but yeah,
this is unfinished bare concrete, correct?
correct.
You brought up a comment about elevator. Are you not familiar with building code? Or, sorry, I retract that. Why would you make this remark about the building having an elevator? What's the purpose?
Move people, there's an elevator. It's just reporting there's an elevator.
Okay. So, is this special? I'm just wondering, because,
I assume it does what every other elevator does.
but isn't this just building code? You have a multi-level building, you got to put an elevator in for barrier-free access, right?
Just pointing out there's elevator service along with stairwell.
Now, your first sentence was, this is a high-end dealership, and I don't understand what that means. What are you referring to?
It's not a domestic dealership. It's not a Ford. It's not a Chevy. It's not a Dodge.
Okay, so the product they sell is what you're referring to. Is that correct?
And the finish and fit that go along with it, yes.
Okay, so the product they sell, and now you're saying the finish. Now, this is finished with tile floors, unfinished ceiling. What makes this different from, I'm looking at a picture, for example, page 15, I see regular tile floors, I see open ceiling, and lights. What's high end about this?
Mr. Newfeld, brought in numerous pictures to depict exactly what the subject property is so the board can make its decision on it.
Your comment was high end. I just want to know what high end
Do
means.
not feel that the build out is greater than, say, your typical Sobeys or your typical retail environment, Save on Foods, or things of that, buildings of such nature that we're comparing them to.
Oh, so you're not, so I want to differentiate. You're saying this doesn't, you're comparing it to other auto dealers or other retail facilities?
Other retail facilities as far as our comparables.
Okay. Now, bottom of page 12 is an overhead. Ever seen a parking lot like this in one of your comparables?
They're making use of no, typically this is atypical, but they're making good use of the frontage along Keniston to expose the retail product that they sell.
Okay, so they are, in this case, fits their product, but you're comparing it to retail stores. You got a retail store that has weird parking like this? Any of yours?
The site configuration for this property is atypical, yes.
Okay. Hmm. You brought up on page a couple of questions on this, starting on page 39, an order. This was dated 2002, correct?
Correct.
And you can confirm that there have been orders before this and after this, which have been written differently for auto dealers?
Yeah, that's why I highlighted the income versus non-inclusion of the cost. There was a few orders beforehand. I believe there's one after this one, Unit 90, Birchwood. But the collection of order decisions that I looked at was around 10 or 12. Don't quote me on them off the top of my head.
Yeah, I just want to confirm that there have been decisions which are not written the same as this one, correct?
Yes.
Okay, and a decision that actually came after this in 2004 actually applied only other auto dealer rents, correct? You're familiar with that? 9039.
That'd be Unit 90, yes.
Okay.
Birchwood.
On this property, I'm looking at this highlight here on page 45, and it says, using the income approach to value, the assessor arrived.
Sorry, what page? I can't hear you. What page?
45. He used the actual lease rate of the subject property at 1086. Do you see that statement?
Yeah.
Okay, and then on page 51, the order applied 1086 a square foot, correct? Do you see that? So in this case, they did not use what you say are retail rents. They used an actual lease rate for an automobile dealership, correct?
Correct. In this case here, yes.
Okay.
I need to provide clarity on that if you allow. We had a modified approach.
Sorry. I'm gonna just ask you before you provide clarity. Were you at this hearing?
Obviously not.
Okay, go ahead.
At the municipal board, we have a test case that's going to govern how we possibility of two other test cases, but if this test case answers enough questions, it may not be the need for the other two. The board will make that decision in its order. We reviewed this in full. Our argument was this decision on a modified approach, because the leases that they used in place here were book rents and determined to be book rents. Even if that's not the case, and arguably, and it wasn't the argument at the board then, at the municipal board for this review, that's not the scenario we have here today. There are no car dealership rents that are arm's length, and there haven't been for as far back as I've looked, some 20+ years. So there would be no mechanism in place to apply this order if it wasn't modified. So we did a modified approach where we did a complete retail argument, big box store, all costs associated with that, to come up with our value. In this case, when we're reviewing, we put
Okay,
all rates in for the income approach. I'm leaving it untouched. And I'm simply bringing in the retail argument that we would have been making.
so how does this then reconcile with the fact that half of all the space in these properties is for repair purposes?
As far as repair.
Automobile repair, a garage.
Where's the vehicle repairs having in the lower level?
No, half of the space on the main level is for repair. It's a garage.
Yeah,
Now, you said you were
Sorry,
using.
I thought you were referring to the lower level.
No, you were referring to retail rents, and you mentioned Sobeys as an example. So does Sobeys repair cars in the somewhere in their building?
No, they don't.
So how do you reconcile this approach with the fact that there's an industrial component to this property type?
part of the argument on the appellant side, or the respondent side. Part of the opposition side, if you want to ever want to phrase it, the municipal board, was that argument.
I'm not asking about the municipal board. I'm asking you on this work.
I'm trying to answer that. Our argument.
No, I don't, we don't, I'm not asking.
Mr. Neufeld, can you let him answer the question as he
Well,
sees fit, please? He doesn't have to give you the answer you want.
No, I don't want any answer. I asked a specific question. I asked how he reconciled it. I didn't ask about his
Mr.
commentary. on the
Neufeld,
municipal
let him
board.
answer, please.
Very well.
Like, again, this is a modeled assessment. I haven't adjusted for it. I'm giving the grounds of the test case appeal. And in case this goes further, I may have a different value if this isn't reaches the municipal board based on that order. What I'm saying is, if you are going to be leasing and renting a building in a retail environment, in a retail node, you're going to lease it for and have it developed for a car dealership, at least at the same rent and rate and performance of other retail, such as Sobeys, big box stores. They're the most similar. That's the parameter those are the parameters that we'd be bringing to this subject property. Because those owners would not give you a lesser amount of rent. They would still develop the site for you, but it would be similar to what those, not the same, but similar, and that's what addresses the municipal order here to those type of properties. The build outs on those are less than what you see in the subject property here. You're not going to see the type of finish and fit that you see here. So the rent and rate of return that you would need would have to be at least at that rate, if not somewhat higher than that. So if we're looking for an apples to apples argument, we can't have that. The board's fully acknowledged that. Both parties made that acknowledgement. It's how do you treat it? How do you value it after the fact? Our position was full retail. And the agent position that we had, their respected argument was some retail, some VSG related and other related. Our argument was not that. So we're waiting to hear back from the municipal board how to do that.
Well, just to follow up with that, are you familiar with the building code requirements for food preparation sites?
No, I'm not.
Okay, are you familiar with Manitoba Health Department requirements for food preparation sites?
No, I did not research that for this appeal.
So you're not aware that there are additional costs that food preparation sites must pay, which a service garage would not then?
We didn't just look at Sobeys or Safe, we looked at all big box retail. There was multiple different retailers.
You brought Sobeys.
Significant amount. There was 79 comparables, I believe, similar to what we have here today. We're looking at it per node where car dealerships are located citywide, but also in the retail nodes that the subject properties will be located for a more localized look.
Do the sites that you have here have air conditioning?
Retail, I'm assuming every single one does.
Okay, and does the garage and the subject have air conditioning?
I believe it's climate controlled, whether they use it or not. That's typical of most buildings.
Sorry, I asked about air conditioning, not climate control. Do you know the difference between an HVAC system that uses makeup versus an air conditioning unit?
Yes, if you have a difference in your argument, then please present it.
I'm asking if you know the difference between this. Don't the garages have makeup airs, direct flow, and no air conditioning? Are you aware of that?
Typical of that, yes.
Okay. So other than that, page 9, the valuation is all model generated.
Again, as I highlighted, it's all model generated and none of it has been adjusted by myself.
And the capitalization rate of 6.1%, does this have a particular source? Do you call it anything in particular? Like I think you probably have this table in here somewhere, or maybe not. Sorry, I'm just glancing through it. Oh, there we go, page 10.
Again, our argument is that There is no car dealerships that have sold. They don't rent. I should say they don't rent on the. They don't rent, someone's buying them based on the income approach for the real estate. The rent that would be income generated to real estate, so. Our next nearest comparable would be retail.
Okay, and is this then derived from retail capitalization rates?
Or at the municipal board, we use the complete retail argument. So
Well, do you know if the model uses retail?
what I'm saying is, this is what the model produced. I can't comment on the 6.10 as far as whether they're using retail. We're making that argument at the municipal board. So for this, I'm relying on the parameters that were put in place. So
Okay, so you don't know where it was derived from. That's really all I was asking. Where the model plucked this from then, do you?
pretty much what I just said.
Yeah, sorry, I didn't catch that. I was listening to stuff about the municipal board. I'm just wondering about the model here.
The model produced 6.1%.
And you don't know how it
It's a
how it came
model
up.
parameter. I did not do the cap rate analysis.
Okay. Those are my questions.
Okay, Ms. Linklater, questions?
My questions have been asked and answered. Thank you.
Mr. McIntyre?
I just have one question. On page 2, you're showing a sale date of 2014, and I'm just curious, was that land only?
Yes, just land.
Okay, thank you very much.
All right, so you didn't make any differentiation between the showroom and the service area on the main floor? That's correct?
The showroom and the surface area and the mezz are all under one. So no. We do make a
Alright.
distinction between the lower level.
All right. Okay, thank you very much. Mr. Neufeld, your presentation, please.
Oh, sorry. Okay. I'll deal with it in direct. I just noticed the discrepancy here. I'm just noting something that we have a difference in square footage, and I just want to see if I can show you what happened here on my report. Yes, no, possibly. The original construction plans were not followed, and there were as-built drawings, and the assessors never caught up. They were using the original drawings, and page 10 gives you an idea of one of the areas that's in dispute. This is a part storage area, and that's racking. That's not a floor. So when it was completed, the areas were changed, and then on page 8, bottom of page 8, this is a equipment storage area above the shop area. We do not count this in the leasable square footage because it's a deck provided to house equipment, and it is not rentable area. Very consistent with the standards that are applied to commercial real estate. The approach used here is, and the assessor did say something that was well known, is that the auto dealers went through several periods of when they were rented and when they weren't, and until I'd say the late 90s, there were very few auto dealer rents, and then beginning then until about mid 2000s, there were a fair bit more. So the first case that was brought into the municipal board, we had no rents, and I brought that in 96, and it was Jerry Gordon Mazda, and it was really the cost versus the income. Board decided income, of course, based it on garages. So there's been a history of municipal board issues on this. That was the first case I know of where the board chose to use the income approach in 1996. 97 maybe, I don't know. I can't remember, sorry. And later on, when the 2004 case was brought in, we actually had 5 real rents, including the one that the assessor referenced, and they decided on that. Since that time, there's been upheavals in the auto industry, and basically it's a crappy investment, and nobody wants to invest in it anymore. So you got to buy your site. And what we've done, as most appraisers do, is we've tried to find the most reasonable method, and this is the method that we were taught as appraisers and quite a long time ago, was to say, let's look at this rationally. Part of this is retail, part of this is garage. It's a blend. So we've always used a blended rate for halfway between industrial, halfway between retail, and the same goes for a cap rate. That's the approach that appraisal has used on the income model on this. And I began my work as an appraiser working for a very large auto dealer ownership group, but that's the history of it. So this is what we've done here as well. So we've looked at a variety of different rents in retail and industrial, and there's been some very, very close rents that are like this, and that would be like a showroom warehouse facility, not a big box, because that's pure retail, but there are several showroom retail facilities, and I think we've got them in our report. So looking at the rents, starting page 3, these are at the top are some retail, and these are buildings like Leon's and Staples and Giant Tiger, basic accommodations. A car dealership is just a shell building. They're all metal pre-engineered buildings. These are industrial buildings. Then there's some finish added, and it's an image package that each dealer specifies on it. It is not fancy. The most expensive part of the image package is the lighting and the sign. But this is how they're made. So the number of these here. Now, the one I thought was very, very interesting was on page 3, the sixth one down, 1322 Waverly. So this is Superlight. Now, Superlight has a showroom up front, lots of lights, and the back is for holding their product. Now, they don't have as much parking as the subject, and that would be where you could make an adjustment. That's in my mind. I mean, this is just down the street, or well, actually, no, a couple blocks away. But this is what this product is. The closest reasonable comparison. It is not a big box store. It is a mix of retail and warehousing. And I think the concept's been all along is people get carried away, bright shiny automobiles. It must be really worth something. It's not. The best analogy best example I can tell you is we all sat at 750 Pembina and looked out the window at that disgusting building next door, the old Ford dealership. It was beat down. It was worth nothing. It was sold for land once it was finished its use as a car dealership. That's because it's just a simple building. And that's what we're supposed to appraise, the alternate use. We're not appraising it as though the Mercedes dealership is going to move into a shopping center tomorrow. What we're trying to do is appraise the value of the dealership if it didn't have a car sales portion in it, or if it was a different use, not substitution somewhere else, but alternate use. And there's where we have the major problem with the assessment department's workup, because they're not focusing on the true nature of value. It's not the use, it's the building. Not moving somewhere else, but what's in place. And if you go through all the auto dealerships that became obsolete over the years, what happened to them? Winnipeg Honda, torn down. Orion Chev, torn down. No, it's still up. Sorry, Westport, the old Westport, torn down. Midway, torn down. The one you're going to hear later today, the old building, they moved. They're forced. They had to go. These are all. This is the nature of value, not the concept of automobile dealership. And I'm just trying to look for a couple more, but it was those that one in Waverly, which really I thought was really an interesting one to focus on. And then we had a couple more here. There were some service garages, and there is a rent that I think is still in place, and that's at the bottom of page 5. That is number 19, which is 2554 Portage. Started life in 63 as Birchwood GM, leased to the Mercedes dealer. They came in to spend some money on some alterations, and the city planning said, well, your building's too close to the corner. So they had to cut down 6,000 feet. But the rent was set at the renewal was $750 a square foot. And actually, this isn't a renewal, this is a sublease. So the original lease was drawn up with the owners of Mercedes. They had a long-term deal on it, and then they sublet it to Birchwood GM Financial Solutions. That's the number. That gives you an idea of what's the life left for in a building and an automobile dealership once you don't want it anymore. Something changes. And there's a number of other ones here. This is our idea of a survey of looking for a site. Another one at the bottom of page 6 is number 23 and number 22. These are in an industrial location, which was altered to become storage in the back or manufacturing in the back for the brewery and retail up front. $12.50, $12. This is next door to the subject, by the way. The parking is a little on the short side on this, which is why we went higher on that. That gives you an idea of what the market for this is. Closer example. And then on we have the pictures, and the basement is automobile storage. It's bare concrete floors, lighting. There's a ramp to the bottom. This is storage parking. Clients are allowed to go down there, and that's why they have to put an elevator in, because it's building code. Been down there, and a lot of the things they're doing, a lot of these cars are on consignment too, so this is part of their business. The pictures on page 9, the bottom of page 9 shows, I was mentioning the mezzanine and the stairwell up to it. That mezzanine was on top and above that on page 8. So this is where the compressor is. That's the big box building there, and there's I believe that's a pump for a wash rig, and then below it is more equipment. So it's stacked equipment storage. Bottom of page 10 is the rack for the parts. On the as-built plans, what you'll see is in this area they'll have an X through it, which indicates that it was open ceiling to floor. So it's not floor area. It's racking in. And sorry, there we go. Page 11. That's the decking up there. That's what the assessment department has in for floor area. And they've never corrected it. And that's not a floor, that's a deck. Page 13, these were just some decisions, and I know you're not interested in what other people did, so those are. Well, the door got opened on something earlier today in questioning, so I'm going to save that for summation. In regard to the capitalization rate, going back to page 2, this is, as we said, we treat this in the appraisal profession as a hybrid retail industrial building. So we looked at, first of all, nobody tracks these cap rates, they don't exist. So this is a hypothetical application. Now, our hypothetical application looks at this hybrid, and we look at the top rate for retail and for industrial, and it's fairly consistent in around the 6.5% mark. And then we look at what makes this better or worse. Now, I didn't prepare this, but I think, yes, the highlights are rather, yeah, I agree with this. So the entrance to this. So there, it's on, has a Keniston address. You do not enter off Keniston. You enter on the side street. So it's more like, it's a sort of a service road arrangement. Happened to be there yesterday, and you know, the access is very, very slow. There's a single light that goes on to Keniston from the Lawson, and trucks use it. Their neighbor is a auto wrecker. Yeah, let's talk about their neighbors: an auto wrecker, an oil recycle facility, a brewery, and a trucking company. This isn't. This is a retail fringe. Good location, good visibility, poor location for getting in and out of. But there were some good things and some bad things on it. But the entrance is very bad. Configuration is, as you can see from the overhead, it was designed to fit the lot. This is a bit of a Mercedes prototype. The actual new Mercedes prototype is multi-floor, and I was just reading in our zoning bylaw that the city does not allow multi-floor display sites for automobile dealerships. That's not relevant, but it is an irregular lot, and so the portion that's long and thin is 2 layers of car parking for display of absolutely no interest in the marketplace. That's for the user only, which means not market value. Market value is not for just automobile sales. It's got to be attractive to other users, and we would call that use value, not market value. The parking in the area is probably the worst thing about this site. At 3.3 acres, it's much too small to be an automobile dealership. The new format is a minimum of 5, high volume 10 acres. And that changed after construction. What happened in this business was that near bankruptcies and bankruptcies of auto manufacturers, they said, no more consignment cars, no more lots where you can pick them from. You buy everything. All your inventory, you got to have your own storage. So for the longest time, Mercedes had a storage space on Brookside Boulevard, and they still use it. They had to buy another lot on Lawson, 237 Lawson, to accommodate their size. And then they developed the auto body shop next door, which gave them more parking. On its own, it's got a very, very low land ratio for its use. And so you know, you think of alternate use, it's not going to be great. And it was built to suit. I think, yeah, I mean, the only other thing I would mention on this is that I don't think that this is in a primary area of interest for alternate users. And we look at this and try to figure out what would go in here as an alternate use. And there might be some uses, but they're far more limited than if you were in the shopping malls, which are south of it, and based on access and available parking. So the adjustment came to 7.65% on that. And again, hypothetical, because these properties transact when they're sold with the dealership combined. And that's the really deceptive problem with trying to analyze sales. Whenever there's an auto dealer sale, it will usually get sold with the business. And the reasons are interesting in that some of it has to do with tax treatment, and some of it has to do, well, actually most of it has to do with tax treatment. The other part has to do with the acquisition of a business where it's difficult to get a franchise unless you buy the building with it. But there's in accounting, there's a value reset when you buy a new building. So if you bought this building and you appreciated the building, and you sell the land, and then if you sell the franchise with it, you ask for more money for your land, because that increase in value from your book gets treated as a capital gain. And but if you had an increase in value in your building, it's fully taxable, because that's what you do. You're in the business of selling cars, but not in the business of real estate. when you get used to it, it's a very simple formula, but the bottom line on this is that tracking sales of these generally always include a transfer of the franchise, and the exceptions were that ugly building 750 beside 750 Pembina, ones like that. So that's our presentation. Thank you.
Any questions, Mr. Poole?
I only have a few. I'll save my comments for summation. Page 5. You stated that you didn't prepare this. Did you prepare page 5?
No, prepare. What do you mean? It's just a summary of rents.
Where is this from? Where is this sourced from?
Variety.
Be
This
specific.
was-
This is not GGS Realty Advisors workup. For the
No.
Like-
As a matter of fact, we worked with Trevor. We exchanged data. So I think we supplied half of these. He supplied some, and I think some came from Altus/Ryan. So we were sharing data with each other.
Same as question for page 6, the showroom retail.
Yeah, again, same idea as we were sharing data. I know that some of these we supplied and some of them he supplied, or Trevor, and I think one or two came from Altus. And you'll also note that there's some repeats here as well. And you can
Page
compare
14.
those charts to page 3.
Page 14. Same question. Did you produce this?
No, this is a recap of those board decisions, and as I mentioned, we're not out to compare other assessments, and I think take it for what it's worth.
Or TGS Realtors Advisor.
Pardon me?
Middle of the page, Unit 20, Unit 40.
Yeah,
Which is Birchwood Properties, Point West.
Yeah.
For rebranded now. TGS Realty Advisor, this is their workup, correct?
yes, no, I mean, we were working together, and my past history with the Chipman Group provided some of this workup, and Trevor took over the job, and it's always been a collaborative effort.
So are you relying on the same argument that GGS Realty Advisors are with a separate and distinct showroom area and a rent for that, and a separate and distinct automotive related area and a separate rent for that?
I'm not familiar with what their final production was like. I've told you what we did.
Okay, getting back to your page 1. You have 3 areas of rent.
Correct?
These 3 areas of rent, are they for 3 separate and distinct CRUs, with separate entrances, separate washrooms, separate providing use enjoyment?
No, they're a breakdown of the different areas, and more of an allocation. And you can see what skews the final number at $10 lower is the high amount of basement space. So without the basement space, the upper levels would be, I'm just thinking off the top of my head, in around $11.50 a foot, and the basement skews it down to 10. It's an allocation.
And generally speaking of your rents that you brought in, almost none of them are close proximity to the subject property. Can you confirm the ones that are close out of all of the rents?
Yeah, actually, I'd highlighted them, 1322 Waverly, and the building across the street, the 2 rents there, and there's a number of here that that are garage usage, like Southside Auto on Pembina. That'd be a garage portion. Same with Scurfield. I'm reading from page 5. So we looked at citywide and local area. So for this particular property, I wasn't highlighting those for locational issues as much as I was for functional issues.
With that, I'll rest questions and I'll have a summation.
Okay, Mr. McIntyre,
I have no questions, thank you.
Ms. Linklater.
I have no questions. Thank you.
Okay, I have one question, dealing with your uh, um, non-recoverable expenses. You claim 3%, yet 3% of 500,000 will be 15,000, not not
Well, I could drop the value, but no, we'll just leave it as is. I'm not, I don't want to like to come into a hearing and say, oh, we made a mistake, we want more. I don't think that's fair ball. So yeah, it's a mistake.
that seems to be 2%.
It is. And so I can tell you what happened here is that the person who made this kind of did an override, says, look, maybe the chairman will never mind. No, I was making a joke here. We did not want this.
Ex-engineer, I always check the math.
No, we didn't want this to be an argument over the non-recoverables, and they represented a very marginal part of it. The issue was rent and cap, and so there was a different non-recoverable in, and it looks like it was just zeroed out. So, and the other one was left at 2. And I noticed the shortfall too. I didn't want to say anything about it, but that's obviously wrong, way too low. Because the taxes on this are well, what would the taxes be? 250,000. Taxes are $5 a square foot alone. Utilities are $2 a square foot. Maintenance another $2 a square foot. So understated, but again, we didn't want to look for that argument. There were too many arguments. Caps and rents were the focus here.
Okay, thank you very much. So summation, Mr. Poole.
To speak to generally, we all know there's a municipal board order coming. I was hoping to have it by now. My understanding is being written as we speak, and it'll be released very shortly. You don't have it here today. We provided a model generated in value at 10,822,000. The comps that we provided were elevated from the model rents, but those are the comps I feel fit for the retail argument that we presented in this board. I feel that's appropriate. And we'll wait and see what the municipal board has to say. But as far as the agent's use of breaking out, I wasn't sure what they were exactly doing, because it appears they're using other agents' workups, which are different for auto related areas and different for showroom related areas, which combine both a retail aspect and a automotive related rent base. And that was the thrust of the agent's argument at this board. Again, not ours, but again, trying to genuinely respect their position. It seems like that was kind of being applied here today. I don't think that should be appropriate here. The same argument that I made there is, this is a one-story building. There is one entrance, there is one exit. Designed for one tenant. There's not 3 CRUs, there's not 2 CRUs. You can't bring in a hypothetical hybrid approach and create one. So at that point, I don't think it's correct evaluating it as such. There shouldn't be that element of splitting up the 2 different areas. We should treat it as one. And ultimately, the retail argument is the one I think that should be brought in. If you're going to have a car dealership wanting to occupy retail space to sell retail product, and part of that is that vehicles are retail goods. You get charged to RST on them when you buy them. That was one of the points of our municipal argument, that's how they should be treated. So what we have is, in that retail environment, you would need a building that's like and similar. And in-box stores are similar in size, similar build out. As far as sticks and stones, car dealerships in some areas have greater build out, as you see here. And then in service areas, there may be perhaps lesser build out. You would need a site that has a specific amount or enough for asphalted areas as far as storage of cars. It's very similar to retail environment where you need patrons parking on site. So all in all, when you look at it from an owner's perspective, that rate of return that you would need to develop a site would be exactly the same rate of return, if not greater, to develop for a car dealership if they chose not to be an owner occupier. So if they're going into the marketplace looking for a site to be developed, any retail owner would be like, we're gonna develop it at least at the same rate that we're already currently getting from other retail ventures. So I do believe that our argument is sound. And I don't believe that the argument that you're doing today here as far as the 14 Kennison are is correct. But that's our position, and we'll wait to hear your order. Thank you.
Okay, Mr. Neufeld, summation?
Before I start, I'm going to ask the board to remember that the assessor opened the door on a certain topic, and you're going to grant me a minute or two of, you don't have to agree with me or deal on it, but I want to say my piece. First of all, kind of objectionable that the assessor would say that I'm using someone else's workup. The first workup on the income approach was done by me in 1996, and every single one that followed thereafter was a derivative of it. And I still remember an assessor a supervisor who called me, and Al Pajak, who saw somebody else doing a workup, and he said, "Did you write this?" And of course I had. Somebody just copied it from me. And we work together, no secret about it. We all have a common issue that the valuation of automobile dealerships is wrong by the model. We don't hide behind the mythical model. This was, I said, I developed it in conjunction with my colleagues in Stevenson at the time for 2004 hearing, and in conjunction with appropriate valuation methodology. I did not prepare the brief for today because I have to write a full-blown appraisal. I can't provide a brief. I can comment on a brief, but I can't provide it. But I can certainly take credit for everything that's written here. And I don't think that was a fair comment. But again, it shouldn't have been part of this. What we presented to you is the approach undertaken by evaluation professionals on dealing with a problem property where there are a lack of credible methodologies. And if you were appraising an apartment block, a strip mall, it's easy. With a car dealership, it isn't. And it's because of the degree of the mix of the business with the real estate. And it's very hard to break apart. So follow the rules. Consider we're just dealing with the real estate, not what they sell, not what they had to make to sell their cars, but just the real estate. And the key has always been alternate use. Now, the building is custom for a certain thing and not conducive to other uses, and that's clear. So the workup is fine. Now, here's where I'm going to make some comments that, again, the assessor opened the door and he's talking about the municipal board. Right now, there are about 450 to 500 open appeals on auto dealers sitting at the municipal board. The concept or the hope of finding an easy piece on this they could be difficult. But we have made some progress, both sides, at moving together. But the key here is I'm very disappointed with some of the rhetoric we're seeing about this. The downside for the city of Winnipeg could be as high as $50 million of refunds. And I'm a taxpayer. Like, we've got to work on this at the first level at the Board of Revision to resolve this, because the appeals piled up. In the beginning, it was the city filing the appeals. And then they told the board, we got this under appeal, so don't change anything. So the boards tended to follow suit and confirmed. And that's not solving anything. There has to be some pressure on the sides to move it. And I'm not opposed to this at all. Move it, get it together, make it happen, find our common ground. And we can't hear the argument, the board's gonna do this, the board's gonna do that. Because I'll tell you what's gonna happen at the board. If they don't like the order, they'll take it to Court of Appeal. If we don't like the order, we'll take it to Court of Appeal. That's just what's gonna happen. And you know, I told you earlier that we had put some stuff in here that I was just gonna use in final argument. So on page 13 and 14, these are orders that the board did with 4 reductions that the city did not appeal. One of the groups they didn't. So
Well,
they're gonna
I will say we do not put any weight on previous board of
Absolutely.
revision decisions.
And this is where you're giving me a little bit of leeway and I'll be done. You're going to go into court. You're going to see they did not appeal these. Where is the fairness and equity? This is what lies ahead for us. So all I'm saying to the board today is we're looking for an independent decision. We'd ask you to ignore every single comment about what the municipal board may or may not do. But let's just look at this from a rational point of view. We got some real estate that's hard to sell, hard to replace. It's all a use value. It's for a car dealership. That's my closing. Thank you.
All right, thank you very much. Does anybody need a break? Or sure?
Yeah, I was going to go to the bathroom before we started, so I could have one now.
Okay, we'll take, how long would you need, Sally? 5 minutes, 10 minutes?
We do 15?
15? Okay. Well, let's make it come back at 1 o'clock then. May as well make it 20.
Okay, thank you.
Okay, welcome back. We will continue with 1717 Waverly. So Mr. Pohl, you can begin on that one.
Sure. File number is 25196. Full number is 030914499200. Unit 5201717 Waverly. The 2026 assessment is for 4,103,000. Built in 2014. 16,134 square feet. If you look on my page. Starting on page 10, we can see that it is a car dealership. It is Waverly West. It is Jerry Borders Mazda is the owner occupier. So we're dealing with the same principal arguments that we dealt with last appeal. So those basic arguments will carry forward. I hope will carry forward to this appeal and to the next appeal. So I won't go into them in as much detail, but I will go over to the rents. Starting on my page 3. Again, same aspect. We broke it up into 6 different areas of the city. Whether you consider these a Kenniston, McGillivray, Waverly, that area. On page 5, we have an average rent of $21.51, weighted average of $20.91, and a median of $20.31 for 416,000 square feet of retail inventory. So you can round that to basically $21. There is a slighter argument that perhaps you should also be looking at just the way it geographically sits. On page 4, being the Pembina Grant area, we can see that for 349,000 square feet of inventory, we have an average rent $19.66, weighted average of $19.27, median of $19.25. So that rounds to approximately $19.25. So either area you're looking at $19.25 or $21. And if we look at page 7, we've applied $15.24 to the subject property. So well underneath what my median market would be. So again, all standard parameters, all model driven. We have 16,134 square feet at $15.24, which produces a PGI of 245,882. 2% for vacancy gives us an effective gross income of 240,964. 3% for non-recoverable expenses, $6 for shortfall, gives us a net operating income of 231,799. Capped at 5.65%, gives a value of 4,103,000 rounded. So with that, I'm on the questions.
Okay, questions, Mr. Newfeld?
Um, sorry, I'm just looking for page 10. Is the overhead view, that red outline, is that supposed to be the subject property?
That is a subject property. Yes.
So the land that's located to the north of that, that's also part of their operation,
Part of their operation on a separate roll number.
a separate roll number. And did you make any adjustments for adding that to the roll or
No, I didn't.
subtracting it?
No, I did not.
This is, sorry, I'm just trying to read here, 13,000 square foot plan with an upper area as well. Do any of your rents contain upper area?
Most big box store rents have all element of mezz storage area. So
Do
yeah,
you know which ones?
I'm not gonna go through 70, almost 80 comparables, but yeah, most big box retail has an element of office area and it usually isn't mezz. So generally, yes.
Oh, sorry, this is your evidence. I asked you a question about it.
Answer your question.
You're refusing to do it, or you don't know?
I don't have it site specific broken out because those leases are encapsulating those mezz. We don't have leases in place that have a separate lease rate for the same CRU for main floor storage and mezz. It's just one economic unit and they lease it out as such. That's what I'm reporting.
One economic unit, sorry, I don't think that's the correct term, but are you saying that they could have
One
both
CRU.
upper level and main level?
What I'm telling you is the big box retail stores that I looked at have a singular rent reported to the department on the ID.
Okay. And so you don't know if this is all plan area or includes any upper area of that?
I've already explained most of them have an element of res.
Specifically, you
Sorry,
can't answer that. I just clarify you don't know. I just want a clear answer.
I can't get into specifics for each lease.
You haven't worked it, you don't know then, is the answer then. Is that correct?
Not for this appeal.
Okay. What type of title does the property hold?
Didn't look into that aspect of it. I believe it's. No, I can't comment. I did look into this appeal.
Sorry, but are you not aware that all the Waverly Auto Mall are on strata title, or is there
No,
common called condominium titles?
Yes, it is a condominium.
Okay. And did you research into the restrictions of usage that are registered on the title?
No, I did not.
Okay. Are you aware that the usages are restricted to only automobile related uses?
I didn't research that. No.
Does the registration of a condominium restriction impact the marketability of a property?
I'm looking at it from a fee simple perspective. Whether it does or doesn't, we had that same argument at the municipal board for our dealership we were dealing with Birchwood.
I'm just
No,
asking your opinion on it, if it did or not.
I can't comment on that.
And you said fee simple, but where does it say fee simple in the act?
It doesn't explicitly say it in the Municipal Assessment Act, but it is highlighted in numerous orders given that govern the act from the municipal board.
Is there anywhere in the act where it says fee simple title?
It doesn't say it in the act. I already explained the Municipal Assessment Act guides us. And board orders from the municipal board govern us. It's not the
Sorry,
first time.
you're saying municipal board orders govern, aren't those orders made based on the evidence placed in front of the board?
They provide clarity to these kind of situations, and this is one of the situations for the BCD test case, which we're going to answer.
Well, the act says market value is the premise of value, does it not?
Yes.
And can a condominium be sold on its market value?
I'm not getting where you're going with this, like, I don't
It's
have.
not
any-
your problem. I just asked, can a condominium be sold as market?
We're doing it on a feasible basis, valuing it at market. I,
The city of Winnipeg assesses probably tens of thousands of condominiums. Do they not put the value on the condominium title for comparing sales?
again, I'm only dealing with the car dealership. It is a condominium. We're taking a market approach. We're taking retail market and using economic substitution for it. Whether there's restrictions within the condominium, the condo corp, that's private. I'm not.
Okay, that's not what I'm asking. There are buildings with condominiums in them. When you go to do the assessment, you do the value of the condominium, don't you? Not
Correct.
you personally, but the department, don't they?
Yeah,
Okay, so they've acknowledged that a condominium title is market value for purposes of an assessment. So why not in the case of the subject?
I don't know where you're going with this, Mr. Newfeld. If you have an argument to make, please make it.
You're answering questions. You're not trying to think where I'm going.
I provided a brief for the fee simple workup and explanation for it.
Okay, if you have no explanation for it, it's fine. I just asked the question because I'm puzzled. Why don't you deal with a condominium title when you do it for multifamily ones? You have, you
I
know
think
that
I've
it's
already
alleged,
answered it.
but you know the act
Mr.
permits it.
Taking my order here.
Okay, so the workup then on page 7 is done by the model then?
Yes,
Was the model told it's a condominium?
I'm not a modeler. I can't answer that.
Okay, thank you. Those are my questions.
Okay, Ms. Linklater, questions?
I have no questions, thank you.
Mr. McIntyre?
I have no questions, thank you.
All right, so Mr. Newfeld, your presentation then.
Thank you. Yeah, I'm just going to deal in the new stuff. You've made it clear where arguments can carry forward. So this is on a condominium title, and a condominium is a form of ownership, which is a fee simple title that's stratified into different units. Very simple concept. Everybody owns a piece of it. Everybody's got to pay for common area costs, and it's marketable. This particular one, as we stated on page 1, is restrictions, and the basic restriction is it must be in automotive use. So no, you can't open a sporting goods store, you can't open a Sobeys, you can't open a dollar store, you can't open any of that. You could probably open a Napa Auto Parts. That's about it, as far as they'll stray from it. So it's a restricted usage, and the concept when they put it together, of course, is they just wanted to bundle the condominium, the auto dealers in one area as a one-stop shop for everybody. The subject purchase, which the assessor highlighted, was a forced purchase. They had no choice in the matter. This has been testified to, so it is knowledge, public knowledge, that Mazda said, "You better move to the mall, and if you don't, we'll find someone who will." And they had to buy this property and move into the mall. Didn't really care for it because where they were located, they did a better service business, and here it's not as good. But that is the nature of this business. And I was saying earlier about all the different things that are done for business reasons rather than for real estate reasons, and we bear that in consideration. Now, the other thing about the condominium title, any rule change requires 80% approval. There is no majority owner here whatsoever. There's no one close to having that sort of clout. It is separate. Both sides of Waverley have separate condominium corporations. So this is only for the west side ownership groups. They recently, it was just a funny story, is the Subaru dealer tried to buy land and hook up to them, and they wouldn't let them. But that's what the condominium can do. So the cul-de-sac that's in front of the subject property is actually owned by the neighbor. And for some reason, they put it on his title as an additional condominium lot, which is assessed separately. So it's a rather interesting relationship. We have applied a rent of $12, and that's the same comparables discussed earlier. And the lower rate than, say, the Mercedes is the inability to find an alternate use. So even though the Mercedes we discussed earlier has had a limited interest, there were still some possibilities. Whereas this particular one, there are no possibilities. It's going to be a car dealer or nothing. That's not a good thing to sell. The definition of market value, the willing seller, willing buyer, no undue pressure, you don't get that here. So any valuation you do on here is going to be hypothetical. In the real world, we would put in an extraordinary assumption and saying that we're not going to consider these, but that's for valuation purposes. For tax purposes, you can't ignore the rights that are associated with the property. So that's why the rent's a touch lower. And then this cap rate here, I honestly disagree with it. I didn't prepare this. I would have put in a significant discount for property rights. That's the top one. Limited property rights. This should really cap in the 8s because of that, maybe 8.5. Just my opinion today. I'm not changing anything, but anytime you get a condominium title with restrictive rights in it, that's the concern. And the rule is, of course, you don't value bricks and mortar and dirt. You value the property rights associated with the site, and that is a negative property right, being a restricted use. But as the chart shows in page 2, imagine the reasons that this could have a change in use is the move to online sales. So right now, there are more and more companies who are doing online sales. If you want to buy a Tesla, I had to buy one. I didn't like it for the company. You ordered it online. They delivered it to your front door. No need for a dealership. And they don't have a lot of service requirements, so you don't need the big garage in the back. That's the change. As we move to more electric cars, you're going to see a decline in the garage use, a lot of obsolescence. You want to repurpose this, maybe what you're seeing also in bigger cities is amalgamation of the auto dealers into bigger ones, 100,000 square feet, get rid of all the smaller ones. That happens, the condominium title will be stuck in place as to a restriction in use. And so an investor is going to be thinking towards the future. The other thing that I mentioned was the lot at the back on my page 1. That's a fee simple title. That was a former railway right of way, and it was decommissioned around 2003, I think. And CN sold segments off to all these property owners. Now, they were all under the impression that they would be able to have access to the street behind it. Some of them built private access to it, and the city came along one day and said, close them up, pour the curbs. You do not get access to Henlow. We're not permitting it. So in this particular case, they paved it and they have car parking. And some of the other ones, they haven't gone that far. And there's it was a bit not a great thing for them, because the idea would be, you're a car dealership, you'd like to have the semi-trailers come in the rear to unload the cars, and then the customers come in the front. So it was great for loading, and that's not permitted. Aside from that, there's no new evidence. It's the same comparables. I mentioned why we went lower with this one, and just double check something here. Well, there is something I was going to point out I didn't discuss, and the other one was on page 43 and 44. This is the Bank of Canada rate. So this is the main lending rate. On April of 2023, the Bank of Canada prime is 4.75. So that means your bank prime, if you're a good client, maybe 6%. If you're not so good, 7%. But an interest rate is the prime ingredient in any loan. And of course, but it's also the prime ingredient of a cap rate. It is directly related to a cap rate. So if you have a 4.75% Bank of Canada prime, and on page 27, there's some discussion, the top shows a spread. It's a 3-point spread. So this would suggest that a 3-point spread from your bank rate is applied for a cap rate. This isn't new. This isn't earth shattering. This is the way we used to work out cap rates. Was the mortgage equity method, and the whole concept behind this is a cap rate wasn't designed for assessments. It was designed for bankers to know if the property would earn enough money to pay its mortgage, pure and simple. So as April 1st, 2023, there was no such thing as a commercial lending rate as suggested by the assessment department model at 5.65% because it fails the test of reasonableness. You can't pay your mortgage because your mortgage is going to be 6.5 to 7% alone, and then you still have to make profit on the differential. So you got to be looking for a cap closer to 8 on this. And again, this is not new information. This is not, this is something that all people who are involved in valuation should be aware of. And I find that any cap rate that doesn't follow the Bank of Canada rate is extremely misleading. That's my presentation.
Okay, questions, Mr. Poole?
No, other than commentary that was already made, carried forward to this appeal. So no, I don't have any other questions.
Okay, Mr. McIntyre,
I have no questions. Thank you.
Ms. Linklater.
I also have no questions. Thank you.
All right, thank you. Let's go on to our final property today, which is 1555 La Gemodia. And again, there's class and liability. So, Mr. Poole, if you can lead us through the tombstone data, and then we'll deal with class and liability.
File number is 25-26-5. Roll number is 040071374000. Civic address is 1555 Lagemodia Boulevard, and the 2026 assessment is for $5,921,000.
Okay, now Mr. Neufeld on class and liability.
Just an error on our part, so confirm them, please.
All right, thank you. So then Mr. Poole back on value.
All right. Well, the property was built in 2020. The leasable area is 26,430 square feet. If we look over to page 10, see where it's located. It's located on Lagemodia between Reindeers and Almy. It has good frontage, has good exposure. It's a Hyundai dealership. They moved from Regent. They were on Regent. They had a site built for them, little off Regent here. So as you can see, it gives good description of the subject property as far as interior finishings. 14 showroom area, page 15 showroom area. And then of course 16 and 17, you have your hallway area, you have your lecture area. Page 18 and page 19, you have your on page 18 is more your quick service area, and on page 19 is more your repair area. Page 20 is your storage area. Page 21 is your car wash detailing area. So it is a pretty good review of some property as far as what was there. As you can see, it's a little less finishing as I was getting to first appeal we had today, depending on the nature of the use of the building, the occupier You may have a higher build up than not, and then you get into retail. For our purposes, our argument, there's even less of a build up for that, generally speaking. On page 22, you see the income and expense questionnaire, the reporting, their costs. They don't report that they are an owner occupier. I don't believe they didn't check that off. But it's commonly known that they are. So, from that point. Touch on the municipal board order from Waverly, we've already reviewed that, bringing the straight to comparables. The comparable is on page, or comparables are on page 3, the first comp. Regent Avenue area. We have 331,000 approximately square feet of leasable area, an average median or median CRU size of approximately 24,777 square feet. The average rental rate is $17.85. The weighted average rate is $18.11, and the median is $17.50. So you can see it's approximately around $18. When we go to the workup, page 7. For the 26,430 square feet, we see that model generated $14.03. So it's a good chunk under the $18 rate. That retail is in that area. That produced a PGI at $370,813. 2% for vacancy. Effective yields of effective gross income of $363,397. 3% for non-recoverables. And $6 for shortfall gives an NOI of $349,323, capped at 5.9%. Gives a value of $5,921,000 rounded. So with that, questions.
Is that your presentation?
Yeah, sorry, I said without open questions, maybe you didn't hear that. Sorry, apologize.
No, I didn't hear that. Okay.
I gotta remember, I gotta speak to the speaker, I gotta speak to the mic and the ceiling, right?
Okay.
Not hear it.
Mr. Neufeld, questions?
Just wondering when this, I take it was model generated, this value?
Yes, completely.
And the 3 we've had today have varying land plan ratios. Does that factor into the rental rate?
As far as the model,
Yeah.
model, that's what modelers produced. I'm looking at the Regent area as far as our comps. So I couldn't comment on that.
So you don't know if the model deals with the land area on this property. And I failed to ask this earlier. Where does the vacancy number come from? Do you know?
The vacancy is a model parameter, 2%.
So no idea. Is this like a retail basis or any? If you don't know, that's fine. It's the same question as the cap rate, and I'm assuming.
I couldn't answer that at this point.
Okay, that's fine. Page 2, you put in a sale. Have you researched the sale?
Sale page 2.
Yeah.
I didn't put any weight on it. I believe it was a multi-role sale for land. So no, wouldn't be applying it.
Okay. And as compared to the other dealer we've said earlier, called it high-end finish, what would this be described as?
It doesn't have quite the same build out. It is a new build. I mean, it's 2020.
Okay. And
It obviously doesn't have a lower level.
on page 19, the service garage, the things hang from the ceiling, oil dispensers and exhaust hookups. You won't find that in a retail store, will you?
No,
And this is a metal pre-engineered building as evidenced by the beams?
it's that way, yes.
Okay.
The roof structure anyways, yes.
Yeah, that's what I was talking about. Those are my questions.
Okay, Ms. Linklater, questions?
Yes, thank you. Mr. Pohl, I just wanted some clarification on the question that Mr. Neufeld asked you in regards to that sale. On page 2, September 2018 for 3.5 million. And I believe you said it was multi.
It was a land only sale. I believe there was another parcel involved, or they split it off. I
Okay.
didn't put any weight to it. I'm not putting any weight to it today.
Okay.
It was an unimproved sale.
All right, thank you. That's all my questions.
Mr. McIntyre?
My question has been asked and answered. Thank you.
Okay, thank you. So, Mr. Neufeld, your presentation.
Thank you. Just to begin, this is owned by the same people who own the Mercedes dealership and built by the same contractor to the same specifications. So I found it surprising that this wasn't high-end finish and yet Mercedes was. It's the same. Been in both and work with the ownership. And when I speak about these properties, my involvement is always firsthand. I will not bring you hearsay. Jerry Gordon, for example, has been my client since, I told you, 96. These people have been my clients since 97. I do all the work now in regard to their sale. There's a bit about it. They had purchased a piece of land on Regent that was to be finished, and then they had signed a termination deal in their old place at 690 Nairn that they were only renting. The land on in Regent became, there were too many delays. They weren't going to make it in time. So this was a last minute purchase decision on La Chaudière, and not their preferred site. And they paid too much for it. And the assessor is correct. It was a larger parcel that then had to have a piece carved off for Ravelston extension. You can see it in the purple. So there were problems with it. I just want to make sure we weren't relying on it because it was a distress purchase. The rents in this case, we looked at pretty much the same. This was a bit closer to the Regent Avenue properties, and so it's a little bit higher rent. We figured at $13, and the cap rate could be a little bit more aggressive because it was more closely located to the retail nodes. Like in difference to the ones we were discussed earlier, the concept for alternate use seemed rather restrictive. For this one, they do benefit from that whole area of heavy retail engagement all along from Plessy all the way to Panet is developed, and they fit into this, and the rents we used were based on this. And we did have quite a few in the area, and the ones I was just trying to point out were on 1520 Regent and 1540 Regent. Those are both in the mall, the one at the corner of Lage and Regent. So they would be expected to have a slightly higher rent on that basis. And there was another Regent sale at rent that we had. I misspoke. 1520 Regent. No, that's not at the corner. That's inwards. So those were the ones, two of the ones we looked at. See, anything else on there was as before. This was altered at the last minute to take out a certain non-recoverable cost, and the number is 2%, and it should be 3%. And the shortfall is understated. Again, we're not making any changes on this. Although they should have higher expenses as before. No, I think that's it. It's just another built to suit site. A fairly low land area though, and that's one of the parts about it. I was saying earlier that the new target is 5 acres of land for a small dealer, and 10 for a larger one. At this point in time, Hyundai's really moving up there to become one of the bigger ones. So over time, they will find they do not have enough land. That's my presentation.
Okay, questions, Mr. Poole?
No, other than the same commentary that we've already gone over, we'll apply again.
Okay, Mr. McIntyre,
I have no questions, thank you.
Ms. Linklater?
I have no questions. Thank you.
Okay, I have no questions, so thank you very much, gentlemen, for your presentations. We've now heard all items on today's agenda, and this hearing is now adjourned.
Thank you.
Thank you once again.
Thank you.
Yep. Thank you.
Okay, does anybody need a short break before beginning the deliberations?
I would, Mr. Chair, if that's possible.
Okay.
5. Thank you.
5. Okay. 1:40 then.
1:40. Shouldn't take us that long to confirm them all. I guess he didn't hear that.